or continuance of a conversation around the community of reparations and the consideration of an economics expert. I will first introduce our two speakers. So Professor Eric Miller has joined us for the community of reparations discussion. Dr. Eric Miller is a law professor at Loyola Law School, where he teaches and writes about criminal law, criminal procedure, evidence law, and race in the law. He is interested in problem-solving courts, including drug courts, the law and sociology of policing, and reparations. His work includes developing national and local litigation and legislation strategies, seeking reparations on behalf of the descendants of enslaved people and victims of Jim Crow segregation and racial violence. In particular, he's worked for over 20 years seeking reparations for the victims of the Tulsa Race Massacre, as well as being briefly involved with some of the lawyers representing the Georgetown 272 Descendants movement, seeking justice for the descendants of people enslaved and sold by Georgetown University. Accordingly, his work also engages with reparations from enslavement to contemporary policing. So we're going to hear from Dr. Eric Miller, and then we're going to take questions and comments from the task force based on his testimony. And then we will hear from Dr. Hamilton, who has a track record of innovative thought leadership and policy advocacy on issues including public investment, asset building, wealth and income generation, jobs and employment, health and family care, democracy and civic engagement, housing and creativity, culture, and the arts. In 2021, Dr. Hamilton provided strategic advisory support to leading institutions ranging from the Detroit, Michigan-based Kresge Foundation to the Silicon Valley-based Omidyar Network. He serves as an appointed member of the New York City Racial Justice Commission. In 2021, Dr. Derek Hamilton provided expert testimony to important policymaking bodies, including the United States Senate Banking Committee, the Joint Economic Committee, and the House Progressive Caucus. Dr. Hamilton is a university professor, Henry Cohen Professor of Economics and Urban Policy, and a founding director of the Institute on Race, Power, and Political Economy at the New School. And Dr. Hamilton will present on the scope of work around the consideration of an economics consultant position. So without further ado, I would like to introduce Dr. Eric Miller. Dr. Eric Miller, you may begin your testimony when you're ready. Thank you very much.
Thank you. I just want to make sure you can hear me. Great. So, Madam Chair, in my testimony today, I want to lay out some of the legal issues surrounding reparation. In particular, I'll address what legally are reparations, who's eligible to pay and receive reparations, and what are the obstacles to reparations, both in federal law and in California law, and what are some of the ways to avoid these obstacles. As you mentioned in my remarks today, I'll draw upon my experience litigating reparations on behalf of the survivors and descendants of the Tulsa Race Massacre of 1921. The Tulsa experience is useful because it will provide some practical examples of some of the legal issues thrown up by reparations and how to overcome those issues. In particular, our legal teams have had to address issues of who's legally liable to pay reparations, who's legally eligible to receive reparations, and what forms these reparations may legally take. So let's begin by answering the question, what legally are reparations? Well, it turns out that's a little complicated because reparations activists leverage a bundle of legal doctrines to obtain redress for historical acts of racial oppression. So there's no one legal theory that necessarily accounts for reparation. Reparations advocates have used civil rights and anti-discrimination law to advance their demands, but they've also used tax law and lately public nuisance laws, among other legal arguments. If we were trying to identify what is distinctive about reparations, we could focus perhaps on the historical aspect, or on the nature of the oppression, or focus on only one form of racial oppression, for example, slavery, that fits the categories of being a remedy for past injury, and one that has inflicted significant continuing intergenerational harm. However, I want to suggest that perhaps the distinctive feature of reparations is that it focuses upon wrongs done by some identifiable individual or organization to some identifiable person or group of people. It's this tight connection between the individual or institution on the one hand and the injury, the victim, and the right to repair on the other, which marks out reparations claims and remedies from other types of claims in the civil rights context. Because I realize I'm not just speaking to a legal audience, it might help to give a rather simple example. So bear with me. If it's too simple, I apologize, but hopefully it'll help to explain what's going on. So imagine a group of kids of all different races went trick-or-treating a few years ago. When the children came back to the house, the black children had less candy than the others. Suppose the next year, the parent sends another group of kids out trick-or-treating. Some of the same kids from last year, some have joined, some have left. Nonetheless, the same thing happens. The parent, acting as the state, might decide to even things out and have the other children share the candy with the black children so everyone comes out the same. Under current equal protection law, because the parent is the state, then the parent has to have some really good reason for redistributing the candy. One reason might be that the parent knows that in the past, black children in this neighborhood got less candy. Even in that case, under the anti-discrimination law developed by the United States Supreme Court, a judge would generally want to establish that redistributing the candy was really necessary, even given these past injustices. Things become a lot easier, however, if the kids tell the parents that certain houses on the block refuse to give certain black kids any candy. Here we have examples of what is called direct discrimination. Some people in the neighborhood treat black kids worse than the white kids. It becomes even easier to justify giving black kids extra candy if the parent, as a state, has done something to encourage or at least passively go along with the people who discriminate in that neighborhood. Here then, we have the classic reparations claim. Someone has done an identifiable wrong by not giving candy to an identifiable person, the black kids who were trick-or-treating. Now there is a strong legal justification for giving the wrong kids extra candy, and even for asking the other trick-or-treaters to help out in sharing the candy around. Each of the wrong children has a claim for having the candy redistributed this time around. But in addition, there may be some children that were also wronged last time around and didn't get the candy redistributed then. Their claim from last time around still exists. And so they may say that, in fairness, they should get the candy from last time around too. So we have two different ways of thinking about what would be just here. One is a claim that it's fair to redistribute the candy because this class of people, black kids, are generally discriminated in this neighborhood. That's a traditional civil rights claim. Another is a claim that it's fair to redistribute the candy because some black kids were wrong this time and some black kids were wrong last time, and each time they erode the candy they should have received were it not for the racist neighbors in the neighborhood. One final feature specific to reparations as a legal doctrine is the idea that these rights to repair can be handed down or inherited by the descendants of the original victims, or what California law calls in a few of its reparation statutes, their heirs and beneficiaries. So if some of the black kids in years past have aged out of trick-or-treating, they may be able to hand their claims for restitution of the candy down to their younger siblings, for example, who are still experiencing discrimination. The reparation is that it focuses primarily on remedying identifiable individual acts of wrongdoing, rather than general claims about the fairness of the redistribution, though it does that too. This way of looking at reparations does not replace, but I think supplements, more general anti-discrimination law. Another way to help us understand the legal status of reparations is to think about how the Tulsa race massacre provides a context for reparations claims. The history of that massacre has become a little better known thanks to the celebration of Greenwood as the Black Wall Street in popular culture, and some recent depictions of the massacre in the HBO series The Watchmen and Lovecraft Country. The first thing to recognize is that Greenwood, the black neighborhood in Tulsa, Oklahoma, was in 1929 perhaps the most thriving black community in the United States, and that's been well described in Professor Al Brophy's book on Tulsa. All that was to end during a night of incredible violence on May 31st to June 1st, 1921, when hundreds of white people entered Greenwood, murdering around 300 black people and burning about 40 city blocks to the ground, rendering about 8,000 people homeless and destitute. The Tulsa Massacre was a massive, intergenerational, race-targeted act of violence that destroyed a whole community's social and economic institutions, its residential and business districts, its schools, a library, and a hospital. A commission, much like the current task force, formed by the state of Oklahoma to study the massacre, or the Oklahoma Commission to study the Tulsa Race Riot of 1921, reported that the city police department and the county sheriff department deputized hundreds of white people to participate in the massacre, and the state National Guard participated as well. The city and the state inflicted catastrophic mental and emotional trauma upon a generation of African American Tulsans and eventually upon their descendants. The city, state, and chamber of commerce attempted to prevent the residents of Greenwood from rebuilding their town and turned away funding intended to relieve their suffering. Cover its tracks, white Tulsans used the terroristic threat of another massacre to erase the incident from the official history of the state and suppress reporting of the massacre so that subsequent generations did not even know about the massacre or did not believe it had happened. Some features of the massacre stand out from a legal perspective. First, the primary wrong in the Tulsa Race Massacre is not the fact that victims were descended from slaves, though many of them may have been. The primary wrongs were the killing, burning, and looting of the victims' homes, as well as their detention in internment camps. It's these wrongs, dating from 1921, that justify a remedy. Even if, as appears to be the case, the detention and forced labor scheme may itself have violated the 13th Amendment prohibition on slavery, that slavery wrong dates from 1921, not from 1821. Second, there were many wrongdoers in Tulsa. Some of the white vigilantes may have acted on their own, others conspired with the rest to form a rioting mob, some of them were deputized by the county or the city, others were mobilized by the National Guard. Each of those individuals is liable to pay the people whom they killed, or whose house they burned, or whose property they looted or destroyed, or who they terrorized. Most of them are jointly liable for the acts of the others because they acted in concert as part of a mob or a conspiracy. The county, the state, and the city are liable because their officers directly participated in organizing, deputizing, and otherwise encouraging the mob. The state is liable because it used the National Guard to clear the way for the mob. So we can show, based on abundant evidence in the Oklahoma Riot Commission's report, that the state, the county, the city, the Chamber of Commerce were all directly responsible for killing, arson, looting, and the involuntary detention of massacre victims. On that basis alone, the state of Oklahoma, the county and city of Tulsa could justify paying reparations to the victims of the massacre or their descendants. Third, even if the city and state law enforcement simply stood by and allowed the massacre to happen, it would still be legally responsible and could justify paying reparations out of city or state tax dollars. As the court stated in City of Richmond versus J.E. Croson Company, a 1989 case that was actually a blow to civil rights litigation, nonetheless, the United States Supreme Court said if the city could show that it has essentially become a passive participant in a system of racial exclusion practiced by elements of the local businesses, we think it's clear that the city could take affirmative steps to dismantle such a system. It is beyond dispute that any public entity, state or federal, has a compelling interest in ensuring that public dollars drawn from the tax contributions of all its citizens do not serve to finance the evil of private prejudice. Fourth, there are different sorts of remedies that could be awarded. The first sort of remedies are, of course, direct monetary payments from the state, county, and municipal governments, and also, in the case of Tulsa, from the Chamber of Commerce, the corporations and individuals involved in the massacre, the injuries they caused identifiable people. The second sort of remedies stem from the ongoing injuries inflicted by the Government Act of Oklahoma under what is called a public nuisance doctrine. The basic idea is that the state's actions harm the property and health of a whole community or neighborhood, and it's effectively the community or neighborhood that demands that these injuries be cleared up. We can show that from the time of the massacre onwards, the city and county's racially discriminatory programs of urban development have inflicted specific harms on the Black communities and neighborhoods of Greenwood and North Tulsa. For example, the city has refused to provide adequate sanitation. It has located medical services in white neighborhoods. It has destroyed buildings by locating a freeway in the black neighborhood, and on and on. These are all individualized, specific wrongs imposed by the city at specific times, impacting the neighborhood and the community as a whole. So the sort of clearing up program we've asked for under the public nuisance theory of community-wide harm includes property development, development of mental health and educational programs, creation of a land trust, construction of a hospital, an urgent care centre, immunity from all city and county taxes, scholarships, and preference in government contracting. So what are the legal obstacles to reparations? First, we should distinguish between reparations litigation and reparations legislation. Reparations litigation faces challenges that the legislation does not. I'll lay out in the main the obstacles facing legislation, and I think there's 6 major legislative obstacles. First, there's often a claim that there's an absence of directly harmed individuals, the claim that, for example, all ex-slaves have been dead for at least a generation. Second, the absence of individual perpetrators, for example, the claim that white Americans living today have not injured African Americans. Third, the lack of direct causation, the claim that it was not this identifiable person who inflicted the injuries suffered by the victims, but some other group. Fourth, the absence of a contemporary legal wrong. Because it was legal at the time, the wrong is a moral one at best and not a legal one. Fifth, the indeterminacy of compensation amounts. It's impossible to determine who should get what and how much. Sixth, specific to California and a few other states under Proposition 209, the claim that the remedies are race-based preference to provide education, public employment, or government contracts, whatever the state's significant interest in remedying discrimination. So what are the ways to avoid these obstacles? First, it's worth noting that federal, state, and local governments have awarded reparations to the victims of race-based injustice, including formal apologies, direct money payments, land restoration, pardons of criminal convictions, restoration of employment, educational scholarships, memorials, and mandatory teaching of history in state schools for at least the last 70 years. However, some of the objections raised in courts is that there's no living survivors, that the perpetrators are dead, and that it's not clear who caused the injuries. These 3 problems as a group address the issue of eligibility, and there's a couple of ways to work around the eligibility issue. The first thing is to recognize that eligibility worries apply to both the wrongdoers and the victims of racial discrimination. Wrongdoer eligibility was essentially the worry raised by the 9th Circuit, which covers California, and the 7th Circuit, which covers Illinois, in some cases litigated in the 1990s and 2000s. In each case, the court said that plaintiffs could not simply rely on the general claim that the United States or various corporations had harmed black people through slavery. Instead, the plaintiffs needed to assert that specific people were harmed in specific ways by specific individuals or institutions. In other words, they had to identify with particularity who are the individuals who caused the harm. The courts were skeptical that the government or the identified institutions were the correct wrongdoers. Our response in the Tulsa litigation was to point to specific people, the city, the state, the county, who engaged in the race massacre. We were helped in that process by the work that had been done by the Tulsa Race Right. Their creation of an historical record allowed us to make the connection between the state, county, and city through the injuries that they inflicted to the survivors, in the first case 125 survivors, in the current case 3 of them, who suffered those injuries, and to their descendants who could claim a remedy. So the task force should identify the different organizations, institutions, and individuals who did the terrible acts of racial oppression. But next, it's important to identify their victims. But before I go on, I should say that many of these organizations are still in existence. In Tulsa, it's the same city that inflicted the massacre and should remedy it. It's the same Chamber of Commerce that interned the survivors that should be held liable for those acts. For Japanese American internees who were the beneficiaries of the Civil Rights Act of 1988, it was the same federal government that sent them to internment camps that provided reparations. So for many institutions, the idea that they're not still around is just plain wrong. Second, remember that the Supreme Court in Crowson said that if the state had become a passive participant in private wrongdoing, it could reach out to remedy those wrongs, even if it was not the direct cause of them. So something beyond strict reparations is allowable so long as the state can show that it passively participated in the wrongdoing by standing back and allowing it to happen, or perhaps creating the legal framework through which it operated. The final problem is the eligible group of victims. The Ninth and Seventh Circuits suggested that the plaintiffs were not eligible to bring the lawsuit, in legal lingo, that the plaintiffs lacked standing to act on behalf of all formerly enslaved Black people in the United States. The court wanted to know how these plaintiffs themselves suffered or inherited the injury. It's worth recognizing that reparations can address this worry so long as we properly address the injuries inflicted by the government actors and plausibly attributable to the government through private actors. First of all, some of California's reparations statutes already allow descendants, in the legal language used in those statutes, the heirs and beneficiaries of the victims, to claim reparations owed to the direct victims of racial oppression. But second of all, there are likely lots of people injured in different ways and at different times by different forms of racial oppression, from slavery on through Jim Crow to the present. So part of the important work of this task force is hopefully the work of charting the wrongs imposed by slavery, Jim Crow segregation and beyond: kidnap, forced labor, maiming, killing, family separation, rape, torture, peonage, land theft, arson, medical experimentation, segregation, community fragmentation, environmental pollution, and all the myriad ways our economic, social, and educational systems have been and still are set up to inflict direct physical, emotional, and psychological trauma on people of color, and particularly Black people in California. One of the wrongs that stands to be redressed is the enslavement of people as chattel property as part of a state-created, maintained, and supported system of discrimination. However, though the wrongs addressed by reparations in the United States might begin with slavery, those wrongs do not end with slavery. As AB 3121 recognizes, the legacy of slavery includes sharecropping, convict leasing, Jim Crow laws, and each of these instances of discrimination and injustice constituted separate, distinctive wrongs attributable to a variety of different individuals and institutions, including federal, state, county, and municipal governments, as well as businesses, schools and universities, hospitals, and other California organizations and institutions. Many of these wrongs still remain unaddressed. Nonetheless, their effects continue to be felt as part of a system of racial oppression. Reparations simply demands that the victims receive the various forms of redress to which they are entitled from those individuals and institutions as one way of addressing systemic racism and racial inequality. So then what about so the task force can propose remedies that directly address these wrongs, to heal the trauma, to mend the injury, to restore the land, to support the student, to employ the worker, to pay the debt. States can pay reparations even when a court says they're not legally obliged to do so. That's what happened in the context of federal reparations to the victims of Japanese World War II internment. They brought a case and lost in federal court on statutes of limitations grounds. It was actually pretty much a reparations case of the type that I've just described. The court said they should have filed their claim years ago, even though they had just discovered some new information that the federal government discriminated against them. The Civil Rights Act of 1988 was the federal government's response enacted to provide the reparations that the courts refused to provide. California can do the same thing too. The Civil Liberties Act created a fund of over tens of millions of dollars, including direct monetary payments to the survivors or their children, to fund research and education about the internment and to compensate for the loss of personal property and land taken or destroyed by the United States government. Furthermore, in Adoran Constructors Inc. versus Pena, another fairly negative civil rights case, the Supreme Court nonetheless endorsed the Federal Civil Liberties Act of 1988. And in Jacobs versus Barr and in Obadeli versus United States, different federal courts upheld Congress's decision to compensate Japanese American internees, but not people of other races of ethnicities, as a valid response to the racial discrimination suffered by those individuals. But perhaps most on point, in 1951, the state of California itself paid direct monetary reparations to California citizens of primarily Chinese and Japanese descent who had their land taken by the state under the Alien Land Act of 1920. A recent article by Jack Chin and Anna Ratner explains that the California Department of Justice found that the repayment was not a prohibited public gift, but the payment could be used to promote the public welfare. Even in the context of litigation, however, the state of California has passed legislation that removed the statute of limitations, so reparation statutes essentially, for lawsuits on behalf of victims of slavery during World War II, Holocaust victims, victims of the Armenian genocide, and victims of the government's Bracero programs. So just as with the civil rights of 1988, California's discrimination against Japanese and Chinese Americans was legal under the Alien Land Act. Nonetheless, the state of California paid direct money reparations to the victims of these land taking. There's thus ample precedent for the paying of reparations in California, and federal law, even allowing for the amendment to the California Constitution introduced by Proposition 209, should allow for those payments as well. So let's finally address whether Proposition 209 stands in the way of reparations. Prop 209, which is now codified into the California Constitution, prohibits racial preferences in education, public employment, and government contracts. Essentially, it prohibits what I called earlier redistributing candy based on race-based classifications, but it does not prohibit remedies for direct discrimination through past wrongdoing. I said at the beginning of my testimony that the best way to think about reparations is that it's a wrong-based remedy. One reason is that the wrong-based approach avoids the problem of racial preferences that are prohibited under Prop 209. The other is that it avoids hostility to race-based remedies baked into constitutional doctrine by some of the more recent decisions of the United States Supreme Court. If some identifiable person has had their life, their liberty, their land, or their labor taken from them, then the person or institution that took the life, liberty, or labor has done wrong and owes that person restitution. Paying restitution is not some form of special treatment or preference. It is the standard way we compensate people for harming them. The same goes for opportunities to buy land, to work in certain jobs, to attend certain institutions. If some person or institution wrongfully excluded another on the basis, for example, of race, then that person or institution must make it up, in part by allowing them to have that job or to attend that institution. Again, this form of restitution is not a special treatment or preference. It's just the standard legal way we compensate people for harming them. Even Justice Thomas has recognized the validity of this wrongs-based analysis. In his dissent in Grutter versus Bollinger, the Michigan affirmative action case, he acknowledged that one of the few instances in which he was willing to allow race-based remediation was, quote, where a governmental institution is remedying past discrimination for which it is responsible, end quote. So to the extent that these wrongs call for scholarship and government contracts, for example, so long as they are awarded on the basis of past identifiable injuries directly caused by state or local government, then they're not preferences at all. My colleague at Loyola Law School, Kim West Falcon, has argued just this point in her scholarship, suggesting that this is one way in which race may permissibly play a role in California education placements. Finally, the easiest way to avoid the application of Proposition 209, which I've detailed a little bit more fully in my written remarks, is to adopt a race-neutral category to award educational places, employment, or contracts. The wrongs that I have suggested, enslavement, peonage, and so on, are race-neutral conceptually. So are remedies targeted to land, including the taking or disruption of or exclusion from particular neighborhoods and communities. There's plenty of examples in California history that call for the righting of this sort of wrong, and so long as they are directed towards the wrong rather than towards racial classifications, then Prop 209 should not apply. Finally, I just want to say something about direct monetary payments. So California's already paid direct monetary reparations to the victims of state discrimination under the Alien Land Act. There's no legal barrier to direct monetary payments, as I've been at pains to explain. However, during slavery and Jim Crow, a principal way used to undermine the humanity of Black people has been to argue that we cannot be trusted to spend our money wisely. This argument has become so deep-rooted that even some Black people believe it. But it's a way of denying Black people the autonomy to determine for themselves what's good for them, and a way that payments to Black people are arbitrarily capped or channeled away from Black people and Black institutions. That is a major feature of the current reparations struggle in Tulsa, where various foundations are right now trying to channel reparations meant for Black Tulsans into white institutions. When someone receives damages through litigation, the court does not get to ask, how are you going to spend it? And I suggest neither should this task force. I've also been at pains to argue that money payments are not. Granting scholarships does not change the fundamental challenges of preschool and elementary school education that determine life outcomes. Pouring money into an already failing system will just perpetuate the injuries that have harmed Black Californians for generations and will continue to harm them for generations to come. I encourage the task force to recognize that reparations is about transformational remedies to repair the wrongs of race-based oppression. This task force can embody that change by including the public, not just as commentators, but as experts who get to tell the task force what that change looks like. What we're trying to work on in Tulsa is giving the people who are most impacted the opportunity to tell their history and to speak the change that they demand. I hope the task force will continue to embody this truly transformative aspect of non-monetary reparation. And I look forward to answering any questions you might have.
Thank you very much, Dr. Miller, for that thorough testimony. Before we proceed, I want to ensure that we have a roll call. So Parliamentarian Johnson, could you presume with the roll call, please? Thank you so much.
Yes, I will. Thank you. Chair Moore.
Thank you.
Yes. Vice Chair Brown. Member Bradford. Member Grills.
Present.
Member Holder.
Here.
Member Jones Sawyer.
Here.
Member Scott Lewis.
Present.
Member Tamaki.
You're muted, Don.
I see him. Okay. Member Montgomery Staff.
Here.
And again, Member Bradford and Vice Chair Brown. Madam Chair, there are 9 task force members and the number needed for a quorum is 5. The number present is 7. A quorum has been reestablished.
Thank you very much, Parliamentarian Johnson. We're going to sit with the testimony of Dr. Miller, and we're going to return to a discussion on that testimony. We're now going to turn to Dr. Derek Hamilton for his presentation. Dr. Hamilton, you may begin when you're ready.
Good afternoon. Thank you for this invitation to present, and definitely applauds and gratitude for the work that you're doing on this extremely important topic around racial and economic justice. So I will introduce myself. I will present some framing and scope of some work. So I'll begin with, I am Derek Hamilton. I am a university professor. I am the Henry Cohen Professor of Economics and Urban Policy and the founding director of the Institute on Race, Power, and Political Economy at the New School. I consider myself an economist who specializes in understanding group-based inequality as a focal point, not simply as an issue. I would consider myself in the genre of stratification economists, ones that try to understand the ways in which identity has consequences in one's life and the costs and benefits associated with investments in identity and the platforms that society structures that might incentivize or disincentivize some of those investments. I also would consider myself a public intellectual. So in addition to generating scholarship, a goal of mine is to actualize that scholarship in a way to improve the human condition and engage with the public in doing so. The institute that I direct, the Institute on Race, Power, and Political Economy, we're interested in the intersections of race, social stratification, power, and political economy with a purpose of promoting economic justice, economic inclusion, civic engagement, and social equity. We begin with a intellectual foundation. So we are truth seekers, and we try to use the rigor of scholarship along with the methodologies that come about from quantitative and qualitative approaches to better understand relationships and phenomena, but with a purpose to translate that scholarship into actionable or practice. And then finally to public engage with media, with policymakers, with advocacy organizations, ultimately with the purpose of promoting a political economy where people can be self-determined, where people can be empowered and structured in a way to promote inclusion, equity, and engagement. We are committed to values. We challenge ideology, but we're committed to values. And again, those values are inclusion, engagement, and equity well beyond class, empowering people. And we do not pursue understanding inequality from individual deficit perspectives, but rather understanding structures and resources that people need to thrive. So some context. Racism has never only been simply an irrational prejudice, but rather a long leveraged strategic mechanism that unfortunately has been used for exploitation and extrapolation that have benefited some at the expense of others. We recognize that the immoral devaluation of Black people has been ingrained in the American and California political economy, and I'm grateful that this committee is interested in a reckoning for something that's long overdue. At issue for this work is government's complicity in generating and facilitating this extreme racial inequality. We can point to our unjust racial wealth gap as an implicit measure of this racist past that I've been describing, that's rooted in a history in which whites have been privileged by government, political, and economic interventions that have afforded them resources and intergenerational accumulation, which contrasts with a history in which Black people, their personhood, and whatever capital and resources they may have established has been vulnerable to exploitation and extrapolation. And again, the key word is by state complicit confiscation, destruction, terror, fraud, and other acts of violence and malfeasance. As a result, today, Black people have, as a group, very little ownership of land or the means of production, and still remain in fear of violence and literal bondage. This history of disenfranchisement is well documented. We can turn to policies like redlining, highway construction, exclusionary zoning, restrictive covenants, et cetera, which have led to the marginalization of Black Americans and constrained their full economic participation. These racial differences cannot be fully explained by a clustering amongst the less skilled. We know that education matters. We know that education matters, particularly within group. However, ironically, across group, Black workers with a college degree are often the most harmed in a relative sense to similarly qualified white workers. And this difference is amplified in economic downturn, where scarcity becomes enhanced privileged positions. In essence, education has not been and cannot be the magic antidote for these enormous disparities that have resulted from state complicit laws, policies, and economic arrangements. Again, we're not trying to diminish education. There's intrinsic value, and a purpose to ensure that everyone, regardless of race, has access to high quality education and curriculum, with encouraging teachers to facilitate their education. But it is a myth that education has been the causal link to the inequalities that exist today. The economic returns to education are structurally different across race. We overstate the functional role of education to the detriment of understanding the past and the functional roles that wealth and power that result from that past manifest today. Wealth is arguably the paramount indicator of economic security and one's financial agency. We cognitize wealth as an outcome, but its true essence is functional. Wealthier families with financial advantage buy additional advantages for themselves and their children. Lack of wealth, primarily inherited wealth, prevent many families, particularly Black families, from accessing this advantage, contributing to the ever-increasing distance between those born with and without resources. So to achieve racial and economic justice, we need what you all are doing, an honest and sobering confession of these historical and ongoing sins. That authentic analysis will counter the social, political, and economic culture that has arisen today that caricatures Black and poor people in general as welfare queens, deadbeat dads, and super predators, and undeserving, and instead pave the way for authentic narratives, more accurate framing, where inequality is grounded in what it's grounded in, which is resource deprivation. That acknowledgement alone is empty if not accompanied some form of redress. So let me get into some of the scope. I propose, explore innovative policies and policy frameworks to develop potential ways to remunerate Black Americans with special consideration, as stated in the legislation, to Black American descendants from persons enslaved in the United States. Especially, we can answer what form of compensation should be awarded through what instrumentalities. Ideas and research topics can include the pros, cons, and implications for potential transfers and various forms of these transfers in the state of California. Examples could include direct cash payments, transfers of land, and other financial instruments, including stocks, bonds, etc. One can look at transfers of institutions. One can think about Marshall Plans. The late economist Robert Brown, who was the founder of the Black Economic Research Center and the founder of the Review of Black Political Economy, a journal, and a founding member of the Caucus of Black Americans, has put forth a lot of these various ideas of forms of payments for reparations, which we can consider and advance upon. He talked about per capita lump sum payments, but a caution is, as was pointed out in the previous from the previous speaker, the concern is less so whether Blacks will misuse that money, but a concern that we could consider is the fact that Black people do not own the means of production in California or the United States, and what a transfer payment can mean with regards to growing inequality when you don't own those means of production. In other words, multiplier effects will be generated, and one needs to consider how those multiplier effects generate or reduce inequality, given one group owns and one group has very little ownership of the means of production. Other forms could literally be transfers of those assets or ownership of those means of production. It can come in the form of land. It can come in the form of even stock ownership. One can even think about reparations being paid out in perpetuity or as an annuity, where the resource from some income generating asset becomes the mechanism by which dividends are paid on an annual basis. There is discourse and built up research around domestic Marshall Plan type programs, in which one can think of reparations in the form of built up institutions, schools, and other forms of institutions as well, one would also have to consider the potential moral hazard that in building up these institutions, that the intended recipients might not be the ones that benefit the most, and some unintended recipients might be able to benefit in a disproportionate way from some of those institutions. There has been conversations around territorial grants. In the past, there was conversation around repatriation. I imagine that might not be one of the high priorities here, but potentially transfers of swaths of lands as forms of payment. So I will end with also saying that another component could be, well, how could this be financed? And the pros and cons of various forms of finance within California, as well as the capacities and implications of that finance.
Thank you, Dr. Hamilton, for your presentation. So now we will turn to the task force members for questions for not only Dr. Miller, but also for Dr. Hamilton. And we have about 30 minutes for this, so we do have some time. At this time, would any member of the task force like to be recognized for a comment or a question? Member Holder, you're recognized.
Hi, thank you to both of the speakers for starting us off on a critically important discussion about the community of eligibility, and we know that is something that the public has a lot of eagerness and urgency and concerns around. So it's important to have this iterative discussion and an ongoing discussion with facilitated leadership from scholars like Dr. Miller and Dr. Hamilton. So I wanted to direct a question comment to Dr. Miller. You know, one of the perceptions that we're hearing in this task force is that you can't have reparations under Proposition 209 unless those reparations are lineage-based, right? That seems to be a common perception. And from what I understand you saying, it actually is quite the opposite, right? Where you're saying that you're actually more in danger of a Prop 209 challenge if your reparations are completely lineage-based as opposed to wrongs-based and specifically tied to iterative wrongs that have occurred sequentially over centuries, right? So I just wanted to follow up with you on this what I see as a misperception that you have to have lineage-based reparations, and the community of eligibility has to be determined by direct descendancy from an actual enslaved person that is documented. Can you comment further on that? And Dr. Hamilton, that's open to you as well.
Sure. And some of it actually ties into some of the remedies that Dr. Hamilton talking about. Descent or lineage is certainly one way of establishing an entitlement, and I don't want to minimize that. But I also, as you point out, think that non-lineage, certainly non-lineage from enslaved persons, is a way of establishing an entitlement to reparations as well. And some of the worries raised in some of the more recent federal cases, so In Chicago, it's the In re African American Slave Descendants litigation. In California, it's a slightly older case called Cato. Is the lineage works both ways, and so it works from the injury down, so from the victim down through the descendants, but it also has to work to establish who was the wrongdoer as well. And some of those wrongdoers can be quite hard to identify. There are some ways of expanding the class of wrongdoer, but in some ways they're similar to ways of expanding the class of beneficiaries. So what you can do is you can say that the state has a significant need to address wrongs that it passively stood by and allowed to have happen. And then the final thing is just remember that Prop 209 is actually relatively limited in many ways. It applies to, by its face, to education, government employment, and government contracting. And to the extent that remedies occur outside those areas, then Proposition 209 doesn't apply. One other thing to remember, and I'm not certainly not the only person to say this, is Prop 209 doesn't apply to race-neutral remedy. And so if the wrong is race neutral, so if the wrong is enslavement, that's race neutral, in part because people are still currently enslaved in the United States through sex trafficking and things like that. You might be able to specify particular time periods if you want to try and more narrowly tailor it to particular groups, because of course enslavement was more prevalent for African Americans before 1865. In the Tulsa experience, we have an act of genocide targeted on a particular community. Acts of genocide, you can define an act of genocide in a race-neutral term and say any act of genocide that happened in the city of Tulsa. There is only one. It was an act of genocide against African Americans. So even where you go around Prop 209 by defining things in race-neutral terms, one of the things to remember about American history, as Professor Hamilton said, was that these acts of violence through white supremacy works through racially targeted acts of violence, and by seeking to remedy, for example, historically specified or geographically specified acts of violence, and what you're effectively doing is, for the most part, targeting the sorts of race-based wrongs that we would want to remedy through reparations. I hope that answered your question.
Maybe I'll add a little slight addition and try to make the case that the harms of the past didn't just lead to individual issues, but rather structural context today. It's the result in large part of the harms of the past that still has ramifications on the ways in which groups are caricatured, the ways in which policy is developed, in the context by which transaction continues to occur, including police violence.
Did any other member like to be recognized for a question or comment? Member Tamaki, you're recognized.
Thank you. I want to thank also Dr. Hamilton and Dr. Miller. Thank you so much. So this is more in the sense of thinking out loud as I'm puzzling through this. Dr. Miller, Professor Miller. So I think the premise that you're saying basically is that if the task force focuses on the wrong, the fact that the wrong, primarily the underlying reality is that it impacts obviously Black people as a race. But if you focus on this specific wrong, whether that is slavery or policing or destruction of homes by freeways, then that is a way to survive a constitutional challenge. And then to the extent that the remedy falls under contracting, education, or employment, then that may be a way to survive a Prop 209 claim. Is that accurate, or am I mischaracterizing that?
Yes, that's accurate.
So the with respect to Japanese Americans, I mean, the specific wrong was the incarceration of this population, the removal and incarceration of this population. There are many differences. I mean, one of them being, as opposed to Black reparations, is that the reparations award only went to people living at the time. So if a person who was incarcerated in the camp died before the legislation was passed and made effective, their descendants, their family members, did not get reparations. And because we were part of that whole effort, of course, we thought that was a terrible outcome. But that was a reality of the legislation. It did not pass down to descendants. That's neither here nor there with respect to Black reparations. I think right now we're talking about two things. One is an uncompensated wrong, a crime against humanity that has cascading consequences. And then there's this continuum that we've been hearing about from each of the speakers of the, Dr. Powell, Professor Powell, is called the badges of slavery, and whether that be Jim Crow or redlining or redevelopment or any of the other things we've been dealing with. But I guess going back to the point, I'm mainly, as a lawyer, concerned about surviving a court challenge, no matter what it is. And so to get out of the gate. And so what I'm looking for is clarification there, how you feel about that. And we're trying to put this sort of constitutional and not violating 209 overlay to solve an anti-Blackness problem, this enormous pathology and ideology of white supremacy, but do it in a way that will survive a judicial challenge. So that I'm most interested in that in your testimony.
So two things. You clearly know the outcomes better than me, but a brief reading of the Civil Rights Act of 1988. My understanding was that some remedies went to spouses and children, but no further than that. But I could well be wrong. But it's certainly possible for the government to contemplate the remedy being handed down. And there are a variety of statutes on the books in California for Holocaust victims, for victims of World War II internment by the Japanese, most particularly, I think, the Bracero program that allow heirs and beneficiaries to recover. Some of those statutes were declared unconstitutional, but on other grounds, because the statutes interfered with the federal government's power to conduct foreign treaties. So basically, the worry was it interfered with federal government dealings with Germany, Japan. But the Bracero program withstood that challenge, and so is constitutional. The second part of your question. So there's been two major challenges: the Civil Rights Act of 1988, the Japanese Internment Act. One from a German claiming that he was interned and he should be eligible for compensation, and one Obadeli by a Black person who claimed that the act was racially discriminatory. And both the DC Circuit Court and the DC Federal Court, they're two different courts for those who aren't lawyers. It's a bit weird, but there you go. found that the racial classification, so the racialized treatment of Japanese Americans during the war was so significantly different from the treatment of Germans, for example, that the racial classification was justified. So it is possible to withstand a constitutional challenge, so long as the court found in this case, you make sufficient findings that, for example, it turned out that a number of Germans at the time challenged the internment, just as a number of Japanese descendants and Japanese people did. But the rationale for interning Germans was radically different and clearly based on valid security issues in ways that the internment of Japanese Americans was not. And so with that sort of finding, you can certainly withstand, I think, given the statements in those cases, but even in Adirond, which, as I'm sure you know, is not the friendliest to civil rights litigation, the ability to pay reparations to victims of the Japanese internment. In terms of Proposition 209, again, it's emphasizing the wrong-based nature. Proposition 209, I think, is best understood as a prohibition on preferences, where preferences are, as it were, a generalized use of a classification to engage in a generalized redistribution of education jobs and contracts. Here, the finding would have to be something along the lines of that there were specific wrongs that were inflicted by different institutions or communities, and that the best way to address those wrongs are through, for example, education, employment, and government contracting. It becomes, I think, easier to do that the closer you get to the present time. So, for example, in Tulsa, with our continuing nuisance argument, where the city of Tulsa has expressly undermined Black businesses and refused to contract, I think we have a good argument there that that's directly discriminatory. And so I think that's the sort of finding that the task force should engage in. And I don't want to go in too long, but one last thought is, as a historical matter, I just think it's really, really important. One of the things that's really striking about the Tulsa Race Massacre is we have lots and lots of pictures of the individuals who engaged, the white perpetrators of that terroristic act. None of them have ever been identified. What you get is, in the words of Monica Bell, a Yale law professor, is an undifferentiated, faceless mob, and so there's plausible deniability that anyone is ever connected with this, and that allows the sort of stereotyping and caricaturing that Dr. Hamilton was referring to in his last comments. And I think the more we're able to identify the wrongs and the specific wrongdoers, the better it is for the health of our community.
Member Groves, you're recognized. Still on mute.
Can you hear me now?
Yes.
Okay, I feel like that commercial. Can you hear me now? Can you hear me now? I truly appreciate what both of you, Professors Miller and Hamilton, have brought to this discussion today. I feel as though we are expanding the perspective on a number of fronts. And so I have a question for Professor Miller and a question for Professor Hamilton. For Professor Miller, am I correct in understanding that the idea would be to identify remedies that are not identified by race, but by wrongdoing? And if lineage means closely related to a particular harm or a particular wrong, then there's a good chance it avoids constitutional challenges. And then also that the extent, I'm trying to pull all of this together, that the extent that the groups have been excluded from, those groups that have been excluded from benefits, such as living in certain neighborhoods, accessing certain goods, et cetera, that there's a good chance that the approach could survive a challenge associated, a constitutional challenge, a Prop 209 challenge. So that's my question for you. I'll ask Professor Hamilton, I'll ask it now in case you wanted to think about it, Professor Hamilton. My question for you is, given the structural nature of post-enslavement ongoing harms, and even during enslavement structural factors, am I understanding correctly that you suggest cash payments would have limited efficacy, that they would not go far enough to both address and prevent continued structural harms?
Just so the quick response to your question is yes, that's right. A slightly longer response would be to give this example. So Representative Jackson from Georgia introduced a bill in the House essentially to waive the statute of limitations on lawsuits against the perpetrators of the Tulsa Race Massacre, the city, the state, the county. It's not got anywhere in Congress, but he's done that. The problem would be that under federal law, only the victims, the direct victims, would be able to get those remedies. And so part of what had to be done was to put in a clause in the statute amending federal law to allow descendants to recover on behalf of the original victims. So you can think of that as lineage reparations. But that's not the only way to go about it, as you've pointed out. It does avoid some constitutional problems, so it's definitely a tool in the arsenal, but it's not necessarily the only way to go about ensuring avoiding constitutional scrutiny. Two other ways to do it are to, as it were, identify a race-neutral wrong and to identify a race-neutral remedy. So if the wrong is a race-conscious wrong, you can still have a race-neutral remedy, and that is completely permissible under Prop 209.
And I think you have four broad categories for form of payments. One is cash, one is assets, one is institutions, and then the fourth is some combination thereof. And they all have various pros and cons. And obviously, I'm not going to go through each of them, but because I don't think you want me to. But there's something, as Professor Miller mentioned, something useful about offering somebody unconditional cash beyond the finance, which is without any paternalism. This is owed to you. Do what you want with it. But that said, assets in general often have more financial power than income because they have the added effect of being in perpetuity. That in addition to one period in time, it isn't always depletable. And then something like an institution, it has that longevity as well. But with institutions, I think moral hazards really become a problem. In that, are there ways in which the institutions don't change or evolve in a way that move away from the original mission or expand to recipients for whom it might not have been necessarily targeted from? Or are some people better positioned to take advantage of the institutional development because of some existing power they may have had to begin with. One other thing I want to say about the cash payments, which is in economics, we usually, when we talk about models of trade, we have a concept called immiserating growth, where in an international context, if you take a country that has is primarily not a finisher of final products, but rather has to trade with another country that makes final products, you, in an unintended way, can make them worse off by offering them a transfer payment. So another way to state this is, with any form of stimulus, not only do you benefit the initial recipient of the stimulus, but it has multiplier effects or additive effects. And those that are better positioned with regards to ownership of capital often take a bigger share of that multiplier effect. And, you know, I could say in detail, you know, you give someone $100, if they spend 90 of it, the entity that owned the product that they spent that 92, their income grows by 90. And then if they turn around and spend a portion of it, and the portion and the next person that owns that entity that they spent it to is also white, then you will have grown the white income in a way that increases higher than that of the black income. So these are some of the considerations we would have to take into account.
Thank you.
So we have about less than 10 minutes left for this presentation. Are there any members that would like to be recognized at this time to ask any last questions to Dr. Miller and Dr. Hamilton? And again, as a reminder, at our last meeting, the UC Research Office gave a presentation surrounding the economic consultant position and shared information about Derek Hamilton and the proposed scope of work. So he has come to this meeting to share or expound upon a renewed scope of work. And so I'm just prefacing that we will not have the time to ratify or that scope of work at this time. We'll have to do that at the unfinished business period tomorrow, and I'll give you all more details about that. But again, I just wanted to wrap up and see if any members of the task force had any last questions for Dr. Miller, or any questions to Dr. Hamilton, particularly around the scope of work, or any concerns around that. I have, oh, wait, Member Holder, go ahead, you're recognized.
Thank you. So Dr. Hamilton, what are the limitations that you are seeing currently with the scope of work, and how can the scope of work be renewed to ameliorate those complications?
The new proposed scope of work is more narrow and specific. I think the original scope would require probably more time. Well, not probably, certainly more time, greater resources, and those are two of the bigger things. And then even perhaps more engagement as to specificity of what exactly it would encompass to be able to define it more coherently.
Yes. So I have, Member Tamaki, you're recognized. Go ahead.
Just a quick point. So we're charged under the legislation with making certain findings, including calculations of reparations, determining eligibility and all of that. So I just want to make sure that with the new scope of work, we'll be able to meet our obligations there. And I don't have the legislation in front of me, but that would be, our North Star. I mean, we have to meet that obligation because that's what we're required to do. And is there anything there that would be problematic? Maybe you don't have the legislation in front of you either, but that's a concern in my mind.
Yeah, and of course, I'm offering a perspective, but this ultimately is the decision of the task force. I think based on even some of the remarks made by Professor Miller, specificity of the harms, I think, narrows that in a more coherent way.
Member Bradford, you're recognized.
Thank you, and I apologize. I had to sign off for a minute, and I just came back at the tail end, and I heard Mr. Miller speaking of Tulsa. I'm just trying to see what nexus you were making to Tulsa, because I'm just curious if the Greenwood situation.
Right, and so just very quickly, one of the ways that we sought to avoid some of the constitutional problems that the task force has been discussing is by focusing with specificity on wrongdoing, so that we could identify specific wrongdoers, the city, the state, the county. In our latest litigation, the Chamber of Commerce, the Tulsa Regional Authority, all of whom have done specific acts, so running a freeway through a black neighborhood to fragment it. And then based on those wrongs, identifying both particularly harmed individuals in the first federal lawsuit, the 125 survivors, and in our public nuisance lawsuit, we can actually go a little bit broader, although it's a slightly different set of remedies, and identify the Greenwood and North Tulsa neighborhoods themselves as being essentially targeted for damage to property, health, and safety. And so the basic idea is that the more narrowly that you can identify the wrongs that are done, the easier it is to argue that the remedy is not about racial classifications, but about repairing specific acts of damage.
Got it. So that being the case, wouldn't Allensworth be a fine example as well that's happened to that African-American town in Tulare County, where it was a thriving town until white farmers cut off the water supply to the town, and then they eliminated the train stop and all but decimated a community that was thriving. And that's a prime example. And again, as the author of the Bruce Beach legislation, I say this is Bruce Beach on steroids, what they did. It wasn't the government directly, but it was those surrounding entities that all but ended that town that sits there today as a ghost town. So I think that would be a great example as well.
So given the way you've described it, and I'd need to do a little bit more research, but given the way you described it, I'd say that's the case. I actually think it's also worth looking into not just acts of, I mentioned this briefly, I didn't elaborate on it, not just acts of property destruction, that's what you're describing, but also acts of property exclusion. There's plenty of towns in the state of California that precluded African Americans as part of their policy from accessing resources, and that's a sort of direct wrongdoing that I think the task force can also consider in sort of the mirror image of what you're describing with Allenstown.
Go ahead, Dr. Hamilton.
And just to add a little bit also, from my perspective, there's also direct harm and iterative harm. So perhaps another approach to at least consider is benchmarks that might have resulted from both the direct and iterative harms as targets for redress.
And I think Allensworth is a great example here in California that we can use. Again, it's identified as a state historical park, but if anyone has been to Allensworth, at best, it's a ghost town. And I think the state has a debt of obligation to make this facility whole and also educate the rest of California of the importance of this town that was founded by a African-American colonel who served this country.
So I have two quick questions, one for Miller, one for Hamilton, and then I see Vice Chair Brown, and we'll close out with Vice Chair Brown. Then we'll go to our panel on gentrification and homelessness. So for Dr. Miller, I want to talk about the special consideration language in AB 3121. So the full title of the task force is, AB 3121, California Reparations Task Force to study and develop reparation proposals for African Americans with a special consideration for African American persons who are descendants of persons enslaved in the United States. So my question is, under the wrong space approach, or basically under the conceptualization that you presented today to the task force about connecting specific harms to specific perpetrators, which will then give you a specific remedy in return. Would there, in that conceptualization, in your opinion, or based on your studies, be people within that descendant group, like within the African Americans who are descendant of persons enslaved in the United States, who would be left out or left behind based on that conceptualization? Or would it be up to us as the task force to be really crafty to find, these specific perpetrators and harms and make sure that it's tied to everyone, so everyone within that group isn't left behind, if that makes sense?
If I understand you, first of all, there's case law saying that Prop 209 does not prohibit investigation at all, so you can consider whatever you want and investigate. To the extent Prop 209 applies, it applies only to the making of awards. In terms of looking at specific groups, I think that my approach would be to demonstrate.
If I could clarify, Dr. Miller, if I could clarify, for example, for that special consideration language for African American persons descended from chattel slavery in the United States, in order to get remedy under the conceptualization that you've offered, do we have to tie that to a specific example like Allensworth, or?
It makes it a lot easier if you do.
Mm-hmm.
So,
right.
So you can do a number of things. You can try and tie it to enslavement in the United States, and in particular, look at a particular time period. So you can look at enslavement in California between whenever in 1865, or the California Constitution of 1879 that then becomes a little less discriminatory towards African Americans, though it continues to discriminate against other people of other races. Or you can, to the extent you pull out further and further, though, the worry is under some of the prior case laws of Cato and Inuit African American descendants, slave descendants litigation. Courts are going to worry about the nexus that you can establish, not, as it were, between the victim and the descendants, but between the victim and the perpetrators. And to the extent that you can make that link tighter, as tight as possible, I think that's going to be key. I think there's a question then about eligibility, because are you going to say all enslaved people in the United States, all enslaved people in California? That might be a sort of issue that you have to engage with. I hope that was helpful.
Yes, thank you very much. And then my question for Dr. Derek Hamilton. So, and this is just for clarification purposes, and then we'll move to Vice Chair Brown. So in October, when the UC California DOJ Research Office came to present and offered Derek Hamilton as an option for economic consultant position, it was with the understanding that the economic consultant would do the following, which is in AB 3121 in the bill text. So the economic consultant would, subsection E, in consideration of the task force findings, find any form of compensation to African Americans, with a special consideration for African Americans who are descendants of persons enslaved in the United States is calculated. And then subsection F, what form of compensation should be awarded through what instrumentalities and who should be eligible for such compensation. The economic consultant is supposed to do both of those prongs, E and F. And so based on the conversation we're having today, and Dr. Hamilton, you can clarify and confirm this understanding. You're essentially saying that you can no longer agree to the scope of work of doing E and F. You can agree to do F, but not E, because E would take, in your opinion, you said, more resources and more time. And so you're at this time can only commit to subsection F, which is helping us to figure out what forms of compensation should be awarded, but not the calculations itself. So if you could just clarify that and confirm that as the correct understanding, and then if that is the correct understanding, if you could provide any recommendations as to how we, as a task force, can fulfill subsection E, which is the part of the actual calculations.
So the latter part is nuanced and would probably require a iterative conversation rather than a recommendation as to how you would be able to fulfill E. I would say that it's resources, time, as well as clarity as to why I've scoped out F and not E. And then I'd also say that I don't think we had complete clarity at the time, and when I guess the DOJ made the presentation in October or September as to the fulfillment. I think that I think that those are my answers. I guess with F, I definitely have a greater clarity, and given the time constraint as well as the potential budgets that are available, that's something that I'm more confident and assured that I could deliver.
Thank you for that. And Vice Chair Brown, we'll close with you. You're recognized.
Madam Chair, members of the task force, I think again, I should underscore that in light of Brother Bradford's comment regarding Allensworth as a community that was specifically destroyed by public policy or responsible agencies, that we should also add to that list the Fillmore in San Francisco, the Harlem of the West, in which the so-called redevelopment agency, which became really black removal, admitted through its own self-study that it did an egregious wrong against African Americans. And the community was dispossessed, economically deprived because of gentrification and the failure to keep the promises for redevelopment. I think that we should be careful to identify, actualize, and give facts to the reality that these communities that were destroyed had a ripple effect in causing psychological, social, and physical harm to African Americans. I think that that's particular, that's exact, and is definite in terms of saying, make amends. Show that you really are sorry for it and you're going to do something about it. You will show some fruits of repentance.
Thank you very much, Vice Chair Brown. Thank you also to Dr. Eric Miller and Dr. Derek Hamilton for your thorough presentations. Again, we'll have to revisit Dr. Derek Hamilton's scope of work discussion tomorrow during the unfinished business portion. Thank you again so much, Dr. Miller and Dr. Hamilton. We really appreciate your presence.
You're welcome. And it's great to meet Dr. Hamilton, even if only virtually.
But one day we'll have to change that. Thank you.
Thank you. Have a great afternoon. So now we're going to turn to our gentrification and homelessness panel. I will now introduce our esteemed speakers. And I would like to also announce that we will no longer be hearing from Pete White today, but hopefully we can hear from him at a later date. So our first speaker is Brandon Green. Brandon Green is the Racial and Economic Justice Program Director for the American Civil Liberties Union of Northern California. In this capacity, Mr. Green provides programmatic vision and leadership for advancing racial and economic justice in the state. He previously managed the Civic Design Lab in Oakland and was an attorney and clinical supervisor at the East Bay Community Law Center, where he helped create and lead the Decriminalization of Poverty Clinic. His recent articles, Too Rich to Be Poor, The Hypocrisy of Indigency Determinations, and Mirror, Mirror, Anti-Blackness and Lawyering as an Identity, were published in the Berkeley Journal of Criminal Law and the Harvard Black Letter Law Journal, respectively. His article, Depraved Necessities, Prison Privatization, Educational Attainment, and the Path to Profit, was published in 2013 by the SRBLSA Law Journal. Then we'll hear from Daryl Owens. Daryl Owens is a housing and transportation activist from Berkeley, California. Owens works at California GIMBY, a nonprofit focused on reforming land use laws as a data and policy analyst. He has been extensively featured in national publications like the New York Times and the Atlantic for leading the movement to remove police from traffic enforcement. His work in building neighborhood support for housing with East Bay for Everyone, a pro-housing nonprofit based out of Oakland, California, has been heralded by the National Low Income Housing Coalition and UC Berkeley's Othering and Belonging Institute. Then we'll hear from Damian Goodman. Damian Goodman is the founder and executive director of the nonprofit Crenshaw Subway Coalition. As a successor organization to the Citizens Campaign to Fix the Expo Rail Line, CSC seeks to empower stakeholder groups in the area of Crenshaw-Leimert Park High Park, my hometown, and highlight the issues of equitable and community-centered planning and development in the pursuit of racial and economic justice for South Los Angeles. As a result of the organization's efforts, over $1.5 billion additional dollars have been invested in the mass transit infrastructure of Southwest Los Angeles, including the Leimert Park Village and Farmdale stations in the Crenshaw LAX light rail line. Last but not least, we have Zarita Jones. Zarita Jones is a native of Los Angeles and a proud matriarch of her family. She is the co-founder of her local LA Tenants Union, where she hosts renters' rights workshops. Zarita is also on the steering committee of End Homeless Now campaign and founded a tenants association of 425 units in her apartment unit to fight back. So now I will turn to Brandon Green. Thank you so much, Brandon Green. You may begin when you're ready. Thank you.
Good afternoon, Reparations Task Force members. My name is Brandon Green. I'm the Racial and Economic Justice Program Director for the American Civil Liberties Union in California. Thank you for having me and allowing me to participate in today's discussion. In my testimony today, I'll first discuss some of the work that the ACLU of Northern California has been engaged around the issue of homelessness alongside our colleagues at the other California affiliates. I will then focus on contextual factors that contribute to Black families' disproportionately high risk of homelessness. Finally, I'll highlight legislative campaign efforts that the ACLU and other coalition colleagues are engaged in to enshrine more protections for unhoused populations. My team at the ACLU of Northern California is currently engaged in litigation and investigative efforts across the region to combat the criminalization of homelessness. As I will note, Black Californians are disproportionately represented in every single one of the jurisdictions that we have been involved in. This is unsurprising. Depending on what estimates you look at, approximately 30 to 50% of all unhoused people in the state of California are Black. The truth is evident in our work and profiled in our recently released report, Outside the Law, the Legal War Against Unhoused People. For example, in Chico, California, where 44% of the Butte County unhoused population resides, Black people are overrepresented by close to a factor of 2. In Santa Cruz, Black people represent 1% of the county's total population, but 8% of its unhoused population. In San Mateo County, where we recently litigated an RV parking ban, Black people make up only 2% of the total population, but overrepresented in the emergency shelter, transitional housing, and unsheltered populations. In our state capital, Black residents of Sacramento are overrepresented among the unhoused population by almost a factor of 3. 13% of the overall Sacramento population, but 34% of the unhoused population. Finally, in San Francisco, only 5% of the overall population is Black, while approximately 30% of the unhoused population is Black. The Black people overrepresented in the unhoused population is neither incidental nor accidental. According to Cal Matters, nearly 50% of Black Californians live in houses that were cost burdened in 2018. Nearly a quarter paid more than 50% of their income towards housing costs. Rent burden being defined as spending more than 30% of income on housing, and severely rent burden as more than 50%. This rent burden has not only pushed Black families closer to houselessness, but has also pushed Black families further into the suburbs away from jobs that require longer commutes. This push out has also contributed to gentrification, something my fellow panelists will likely touch on in more depth. The City of Oakland's Department of Race and Equity put out an equity indicators report in 2018. The report found African Americans were 41 times more likely than Asians to be homeless. Additionally, of those housed, almost 1 in 4 African Americans did not own their homes. And the majority of African American census tracts had the highest rates of eviction notices. African American households were also 1.67 times more likely to be rent burdened than white households. Furthermore, the home loan denial rates for African Americans was 2.13 times higher than the rates for whites, and white homeowners were least likely to still have a mortgage or loan on their homes. 69%, while African Americans were the most likely to have a mortgage at 79%. According to Cal Matters, the Black population has plunged by 43% in San Francisco and 40% in Oakland, respectively. The intersecting factors have been of great concern for our colleagues and partners in Oakland who work on education equity issues, particularly around the parallels between school closures, predatory lending, and disappearing Black populations. Recent reporting has highlighted racial discrimination in other aspects of housing, including housing appraisals, where researchers found that 12.5% of homes appraised in Black communities were valued at less than the original cost of constructing the home. That figure compares to 7.4% of homes in white neighborhoods and 9.4% of homes in Latino areas. Not only are Black people disproportionately represented among the unhoused populations of California, but they're also overrepresented in our source system. These two realities are inextricably linked. A 2018 California Health Policy Strategies brief using data from Orange County, Los Angeles, and San Diego found that there was a 26% increase in the number of unsheltered homeless individuals from 2013 to 2017. Furthermore, reported that of these unhoused populations, 70% had a history of incarceration, 28% had recently been released from jail or prison, 13% had been under community supervision, probation, or parole, 32% reported having mental health issues and being formerly incarcerated, and 15% reported both a serious mental health illness and being formerly incarcerated. The Southern California data syncs up with what we know from the 2019 point in time count in 3 California counties as well: Butte County, San Mateo County, and Santa Clara and Santa Cruz County. The ties between homelessness and the carceral system are important because of the impact the carceral system has as an originating life factor for people. A report from the Coalition on Homelessness in San Francisco found that incarcerated people are between 7 and 11 times more likely to have past experiences of homelessness than the general population. Between 25 to 50% of homeless people nationwide have a history of incarceration. In addition, a report by the Prison Policy Institute titled Nowhere to Go, Homeless Among Formerly Incarcerated People finds that formerly incarcerated people are nearly 10 times more likely to be homeless than the general public. It is also important due to the ways in which jurisdictions develop and implement ordinances that further criminalize unhoused populations as a means of pushing those communities out. This approach has been borne out in the various jurisdictions profiled in a report, who as a means of either controlling or pushing out unhoused populations, enacted ordinances that have a cascading economic consequence and carceral consequences that prevent people from exiting homelessness, ticketing them for the behavior that can either be prevented or avoided, saddling them with debt that they cannot pay, and placing them at risk of arrest via bench warrants that also serve to prevent them from accessing necessary services. These anti-homelessness laws are crafted to avoid judicial scrutiny, but enforced to regulate public spaces like their exclusionary law predecessors, i.e. Jim Crow. They do this by creating scenarios where unhoused individuals are forced to either leave the jurisdiction or break the law, and by empowering police to remove homeless individuals from public spaces. These approaches to homelessness have historical undertones and direct parallels to anti-vagrancy laws and segregationist policies wherein people of color were excluded from public spaces and accommodations because they are said to be dangerous or diseased. Any discussion of reparations must take in consideration the surrounding factors that contribute not only to the lack of wealth accumulation for Black people, but the current ways in which Black people are actively being pushed into homelessness and out of communities in which they have historically resided. Along with our coalition partners with the ACLU of Northern California, are hoping to introduce a piece of legislation that would make housing status a protected category to give unhoused communities one more layer of protection and advocates one more tool to fight against policies that, although framed in a racially neutral way, have a racially discriminatory impact. Thank you.
Thank you so much, Brandon Green, for that thorough testimony. Now we will turn to Daryl Owens. Daryl Owens, you may begin when you are ready. Thank you.
I brought a presentation I sent. Does someone else do the slides, or do I just do the slides?
Staff will assist you with the slides.
I'm preparing them right now. One moment, please.
Anyways, I'm Daryl Owens. I'm happy to be here and talk to the task force. I intend to not only talk about my personal experiences with gentrification and what I've seen from a lot of the data work that I've done on the impacts of housing affordability in California, but also propose a couple of solutions I think that the task force should consider.
Thank you. We're looking forward to it.
The slide should be up.
That's not mine. That's Goodmon. I'm Daryl Owens. It should be housing issues facing Black Californians.
Apologize.
No problem. And how long do I have? Like 10 minutes, 10, 15 minutes?
10 minutes.
Okay, great. That's it. Great. Yeah. So let's go to the first slide, please. Or I guess the second slide. So the census data from the recently conducted Census 2020 shows what we already know, which is that there is a large exodus of Black Californians out of the state. They are obviously being priced out from the housing unaffordability. And as we can see here, the big hotspot is Alameda County, which is where Oakland is, and Los Angeles County. Next slide, please. This is another map that I've compiled using census data showing that the decline of Black residents is heavily focused in Oakland and actually much of the historic Black enclaves in the Bay Area, such as Richmond and San Francisco. And you also see a similar pattern happening in Los Angeles around, Compton and Inglewood. Next slide. One of the very important things to understand about gentrification is that we tend to talk about it in the recent 10-year economic boom that California has undergone. but it's been a problem for quite a while now, for many decades actually. And if you look at, for example, the decline of Black residents in the 2000s versus the 2010s for a lot of cities in California, here we see Oakland, LA, San Francisco, the decline of Black residents was actually greater in the previous decade than it was in the 2010s. And this is clearly motivated by also the growing affordability crisis, but primarily the subprime crisis, in which Black folks were foreclosed and displaced en masse. And this is something that needs restorative justice and not restorative, but reparations to combat, because it has essentially eliminated a large swath of Black wealth and caused a mass exodus out of the state or to suburban and rural areas far away from their jobs. Next slide, please. So we see that a lot of Black folks are moving. I don't know if I can drop in the chat anywhere if there's a chat. I don't know if that thing exists, but in case it doesn't, I compiled a map of where Black folks are generally moving to, and they're generally moving to southwestern cities like Phoenix and Houston and Dallas, King County and Seattle. These are the sort of top destinations for Black residents. These are the fastest growing Black cities in Atlanta. Their homes are just much more affordable. They build a lot more than California does, and this is leading to an exodus to more cheaper places. And I believe that, can you move to the next slide? I think it's on this slide, but maybe it's not. It's not really. Okay, the reason why is because what we see, and at least my experience with gentrification, is that a lot of these communities are, renter communities. So I grew up in an area of a lot of Black homeowners and a plethora of Black renters. And a lot of people are leaving California because, no, you don't have to move to the next one. Thank you. No, that's fine. A lot of Black folks are leaving because they're trying to build wealth. And home ownership opportunities are locked out for them in the state of California or in areas where they would live. So this is a huge problem that we need to confront, which is how do we stop the stem of Black folks who are seeking home ownership from just going off to other areas. And so these are a list of reasons why I think that we need to solve this problem. Gentrification is causing a lot of evictions, which has led to a massive increase in homelessness. Homelessness, of course, got a huge boost after the foreclosure crisis. That's when we really started seeing the shanty towns and the large tent cities because of the foreclosure crisis. We know that Black schools are heavily underfunded because they're dependent on the value of property, and Prop 13 has done tremendous damage to Black schools. And we have a pretty Jim Crow-like economic system where wealthier suburban commuters come into large Black metros and extract wealth but don't pay taxes into the local system, which in turn leads to disinvestment. We also need to address the largest contributor to Black suffering in the last century, which is redlining. And this is something that, we tend to focus a lot on slavery, and slavery is very important. But the denial of Black people to live in certain neighborhoods, the denial of the GI Bill, the FHA not giving Black folks mortgages, essentially prevented Black people from building wealth like their white peers did. And this in turn has led to a never solved, never ending, perpetual wealth disparity between Black folks and non-Black people. Next slide, please. Thank you. So what are some issues in particular that Black renters face, right? So as I discussed earlier, Black renters are leaving the state, a lot of them because they're trying to find home ownership and they're trying to build wealth. They don't want to pay their landlord their wages forever. We have an issue with Section 8 users who face endless landlord discrimination. We have an issue, as the previous speaker noted, prior convictions, particularly felony convictions. It makes housing almost impossible to find nowadays for people dealing with felonies. And subsidized housing in the state of California is oftentimes built in formerly redline areas themselves. And these are part of the problem. And Black renters are also severely rent burdened. So a couple of proposals that I have that the committee, I think, should look into is passing a prohibition. The state legislature should pass a prohibition on source of income, and background checks to any severe extent. Ultimately, for a landlord, I think the only thing that should concern them is their ability to pay. Using people's past against them, especially in a predatory criminal justice system, is a great way to keep Black folks in perpetual homelessness. I think that for a lot of urban areas, we want to look into co-housing ideas. And I would like them to also have, in addition to being co-housing systems, maximum planning flexibility. So that I mentioned Fillmore in there. There's a really good Fillmore cooperative that is mostly Black, and they're going to use like market rate units and commercial to like generate lots of revenue and build wealth. I think that we should also look at lending practices for potential Black homeowners to buy housing. That frankly, if you have any history or a family that was denied loans in the previous century, and it was by the FHA, it was essentially racialized discrimination that was completely legal at the time, you should have a much lower standard to acquire a loan than other groups of people. It doesn't have to specify race, but FHA redlining will clearly consistently indicate people of African descent. Next slide, please. So issues facing Black homeowners is that, and this is a very prominent problem from where I'm from in Oakland and Berkeley, is that a lot of Black homeowners, as soon as they run into a financial issue, cash out their houses. And because that's the only asset of value they have. So you have a lot of Black folks with low incomes, and all of a sudden they're sitting on $1 million house. Reverse mortgages are a primary way in which a lot of Black folks get displaced in California. This is a huge problem because this means that they don't have any other sources of income. We also have some Black folks living in, unsafe conditions because they're subdividing their homes illegally without proper standards. And we have an issue too, which is that a lot of Black folks, when they're homeowners and they sell their houses, they don't sell to other Black folks. A lot of other communities just don't do that. They try to make sure that land and property stay within their community, but Black folks, in order to get the highest amount of money they possibly can, are oftentimes forced to sell to people who are not Black. So there's a couple things we need to do here. I think number one, this has come up in Oakland a lot among community groups, and I think this is a really great idea. Recent laws that allow for multifamily housing, that we should not only help and assist Black homeowners in building a second unit, but also basically finance it from a public sector. This will allow a lot of Black homeowners to build wealth without actually having to sell their homes, which is a really great idea. I think that we should push on. I think that we need to absolutely fine and penalize assessors who are undervaluing Black property. If an assessor is found doing that, then they need to be barred or heavily penalized. And those are some of the big two things that I think we can do for Black homeowners in the state. Next slide, please. This just breaks down some, I think, reparations that would be really good. I mentioned earlier about, cooperatives and community groups doing their own housing projects. This is very common in Canada among Native Indigenous nations. I don't know how to pronounce the name, but if you Google that name, Stinakwu, I can't pronounce Stinak, I believe. This is a really big example of Native nations in Canada building wealth through building housing and through providing housing for their own communities. They do both. It's really smart, and they have complete control over their land as a reparation. I think also if we want to look at public housing, there is currently a public housing bill in the legislature that I helped contribute to with my group East Bay for Everyone. And there's a lot of good ideas from places like Singapore for where the government builds public housing. But unlike public housing here, where there's no way to build wealth in it, you just essentially pay rent. In Singapore, you own the public unit under a century-long lease. This can allow for public subsidies to give Black folks a rightful reparation and building up equity paid for by the state. And also we could look to and this isn't necessarily reparations, because we should separate reparations out from how to solve the housing crisis in general, but there are places like Houston, which has reduced homelessness considerably by building a lot of affordable housing and doing a lot of hotel and motel conversions, and also just keeping prices down in general. Not perfect by any stretch of the imagination, but it is, I think, something that California should look towards as well. And that will end my presentation. Thank you very much.
Thank you very much, Daryl Owens, for that enlightening presentation. We will now turn to Damian Goodman from the Crenshaw Subway Coalition. And Damian Goodman, you may begin when you are ready. We can't hear you. I don't know if it's the headphones. I'm not sure. We can't hear you, Damien. It says you're off mute, but we can't hear you. So the audio is still not working. There's a staff member that can assist Damien. We can't hear you. I'm not sure if logging in and out would be helpful. I'm not sure if the staff member can jump in and assist him in the back channels.
Well, we will do our best to try to, Mr. Goodman.
Okay, we'll move on to Zarita Jones, and then we'll return to Damien Goodman. So Zarita Jones from the LA Tenants Union and Crenshaw Subway Coalition, you may begin.
Thank you so much. And can everyone hear me?
Yes.
Oh, wonderful. I just wanted to say thank you very much for the opportunity to be heard today. When trying to examine the problem that we're having with housing and within the current year of 2021, we have to historically actually look back and try to figure out how to correct the wrongs of the past and make it equitable for African Americans and the descendants of freedmen.
Ms. Zarita Jones, I'm not sure if you, I'm sorry, I don't mean to interrupt you, but I just wanted to acknowledge that your camera is off. I'm not sure if that's intentional or not.
Oh, how about that? There you go. Is that better?
Yes. Yes, that's better. So could you restart and then we'll go to Damien Goodman. So
Sure.
Your presentation. Thank you.
I just wanted to say when trying to examine the problem that we're having with housing in the current year of 2021, we have to historically look back and try to figure out how to correct the wrongs of the past and make it equitable for current African Americans and the descendants of freedmen. When thinking about the housing crisis and what we have now, specifically after COVID, that has brought to light, it is shown that blighted communities and communities that were disinvested in there's three different factors that are very, very troubling, including those factors are the eviction history and the incarceration rate and the overall view of African Americans in housing. The first time I heard an owner and their management team refer and address my mother as you people, it put a very interesting light on the conversation and the meaning in any way, shape, and I'm not trying to sound racist in any shape or form, but we were living in a fourplex and we were the only African American families that were residing there. And we had all Latinx neighbors. My mother was always accused of something that she hadn't done regarding, discarding furniture in the yard or having more than one vehicle crisscross parked in the yard. Along a few other things that she always never had any part. It seemed as though that we were always targeted with notices and threats of eviction and things that we had never done in our lifetime. This brought to light something that I had seen as a pattern over the last 30 years, but I couldn't really put my finger on until an extensive investigative report was done by one of the attorneys in the city of Los Angeles with the Right to Counsel Coalition. I became a part of the steering committee, and we're still fighting to codify this right. But it was actually passed so that every tenant that receives an eviction notice can have the right to have an attorney represent them in court. The struggle is still continued for funding, of course. When the Right to Counsel was formed It was collaborative work between 10 different law firms that represented tenants that were served with evictions and 10 community-based organizations that assisted with educating rates. The organizations got together and they formed, which is now Stay Housed LA. There's actually a website, stayhousedla.org. With this unique relationship, it uncovered something that was very disturbing, and something that I had suspected, but never could really put it together. But I saw it was actually put together in a very informative and constructive way. Oh, Montano, he did an eviction report. It's actually can be seen. It's called the LLC Landlordism and the Eviction Machine Gentrifying Los Angeles. The information would bring to light that, because of attorney-client privilege and confidentiality, it was discovered that a lot of the individuals that received unlawful detainers, it was found that they had received previous evictions filings on them in past years. The pattern was started to become really, really apparent because there is a system in place where landlords that own multiple buildings and units within a community arbitrarily filed evictions on tenants within buildings every 18 to 24 months. And so with these filings, they would also use the scare tactics and taunt them and harass the tenants. And the owners would also cease making all the repairs. And even if the tenants would leave, the filings would actually continue. And 9 times out of 10, the tenant would result in getting eviction on their record by default, not even with their knowledge. One of the major, even if major repairs needed to be made within the apartment, like water damage or some other major issue, it would result in a constructive eviction to the tenant. It was cheaper because no matter what went wrong, they would just blame the tenant. Even if there were habitability and maintenance issues, they would get rid of the tenant. They would fix the problem without them being there. It was a zero cost to them for relocation. They would keep the person's deposit and possibly filed a default judgment on them that the tenant would have to pay later. And then all of the renovations that they made and that were done were paid by the tenant. And then, of course, they would rent the apartment to the next person at a higher market rate. Only to note that what we've been finding within our community is most of the apartment units had delayed maintenance for years and sometimes decades. So that's very problematic. What was also discovered is that the people that had been in the units the longest, they were the ones that were they were actually targeted. And even if these rents were rent stabilized, the rents were so low for them that sometimes they would have been there in this community for maybe 10, 15, or 20 years. It was worth for the owner to evict them and to increase to the market rate after they departed. Now, this creates a very systematic machine that destroys the reputation and the credit and the ability to find housing for these individuals. What we also have discovered is that the tactics that were utilized were done in predominantly African-American neighborhoods. And some of them had a very high population of Latinx. But the only thing that they would do is just add the threat of ICE that they were already using. This creates a very serious problem, and it adds to the factors that I kind of mentioned earlier. One being eviction, because a constructive eviction is still an eviction on record. The second aspect is, along with a court judgment, that affects the individual's credit rating and their ability to obtain housing in the future. The third, of course, being if any time one of the individuals had spent some time being incarcerated, many leases had clauses where they couldn't return home or even visit their family members, irregardless to if it was a husband or wife, or maybe a son or daughter returning to their very same address. And of course, the overall negative views of African Americans in housing, period, and attitudes after years of disinvestment in the rental units by the owners and the neighborhoods by the city and some of the counties. When it comes to housing and incarceration, so much there's no such thing as a person having to have paid their debt to society and then to move on and move forward. The system is, put in place that automatically upon release, that there's no place for the person to go back home and get on their feet. The family is forced to sometimes relocate if they want to maintain being a whole family unit. And it subsides what we were finding is that those families are not able to really afford to do that. The situation becomes really heartbreaking when we look at the statistics of African Americans that are incarcerated, but no one really examines, time that may have took a deal or was, released without even having a trial and were actually not guilty. And to me, that is like a gateway to homelessness. That in itself is only partially addressed in the social equity program for minor offenses, like marijuana, and that's kind of like a different aspect of reparations, that we were dealing with in Los Angeles. But when it comes to housing, we look at the three factors that I mentioned before, and those three factors make you 100% ineligible for affordable housing. We really need to examine how the most of those that are in the most need, that reside in low and very low income, brackets, are subjugated and removed, and they become ineligible for the very housing that was actually designed for them. This aspect also is what causes homelessness. We look at the explosive and the exploitive nature of how systematically everyone with more resources coming from somewhere else can replace and be given priority over longtime community residents within the same neighborhood. And that aspect is just gentrification. We need to also give consideration to housing being the key factor and instability and a component to a healthy and sustainable life. Everything else actually improves with having a safe and habitable place to stay. When you can live somewhere and not be worried about the stresses of being displaced. All of the determinants of health are tied to a person's individual housing and having a long-term and permanent place to live. Most of these things include income and their social status, basically social support networks, quality health care and hospital, urgent care centers and their treatment, education and literacy, these materials and resources, unemployment and working conditions, benefits and pay equality, social environments where there's enough green space and locations for recreation, exercise, entertainment, and along with cultural relationships, physical environments, basic amenities that are located within the community, and just plain fresh air, personal health practices and coping skills, having a safe and secure place for a person to rest their head at night without the feet removed, and to be able to provide for one's personal hygiene on a regular basis. Healthy child development with parks and activities for the youth, and also food security. The absence of food deserts and plenty supermarkets and local farmers markets and healthy options, with organic foods. When it comes to reparations, the solution would have to be able to even the playing field. It would have to be, dished out in an equitable manner that's irrevocable, and does not expire for African Americans. The solution of monetary or benefit should have a value that's quantitative. This value should not diminish. And if not used all at once, the portion not used should increase by interest. It should have a consideration to the area in which the individual resides, whether it be a relocation or due to economic factors, or a place that a family has migrated to years earlier. There should be no limitation on the housing type or size, features, yard, or even, like I said before, location. Priority should be given to any purchase of a property that had a racial covenant upon its deed. And additional property priority should be given if the property is purchased or owned in a previously red line district. We could start by acknowledging and give a formal apology and have formal teachings and the laws and policies that California has partaken. And first, we can start to heal past wrongs in the state African American housing. And, I have a short list, but it's not limited to, previous histories of burnings and massacres should be fully compensated. Redlining should be given priority. Eminent domain should be prohibited. Racial covenants should be expunged. Flooded towns should be completely compensated. Broken windows, the records of those individuals should be expunged. The California Constitution, Article 34, should be repealed. Gang injunctions should be abolished, and nuisance abatements should be banned. And all of these when it comes to housing for African Americans. The injuries are overlapping when it comes to the housing in Black communities, and the ability to obtain and remain in their homes has been difficult enough. The ultimate goal for African Americans is to obtain, remain, and ultimately be left alone. And I wanted to give you and share with you a quote of one of my good friends. She's Korean, and she always said that because they have always concentrated on keeping the African American down and disenfranchised, she said she's noticed in the last 30 years that, they've actually ignored the Asian population and they were able to thrive. And so I thought that was a very interesting quote, but I just wanted to share that. And I also wanted to tell everybody thank you and for giving me the opportunity, and I appreciate you listening.
Thank you so much, Zarita Jones, for your powerful testimony. So we'll now turn to Damian Goodman. Damian Goodman,
can you hear me now?
Can we hear you okay? Yes, we can hear you fine. You may begin. Thank
Awesome.
you.
Thank you. First, there's a presentation, but as that comes up, I stand here today on the shoulders of my ancestors. My great-great-grandfather, Charles Blodgett, and great-great-granduncle, L.M. Blodgett, son of enslaved Africans, migrated to Los Angeles from the segregated South around 1904. They literally built much of Black Los Angeles. They were builders who built many of the historic structures on Central Avenue, including the first headquarters of Golden State Mutual Life Insurance. They built the first FHA-backed housing for Black people in all of America, the Blodgett Track, much of which was destroyed with the construction of the 105 freeway. In the 1920s, in response to white banks' refusal to provide home loans to Black people, they founded Liberty Savings and Loan Association to provide mortgages and four walls and a roof to Black people seeking a safe place to, at least in a racist society, call their home their own. The bank, which survived the Great Depression, would be acquired through a hostile takeover from a white bank in the 1960s. L.M. Blodgett, who was known as Old Man Blodgett, married Nella Allensworth, the daughter of Colonel Allen Allensworth, and Josephine, who moved down to Los Angeles to be with them in the 1920s after the colonel's untimely death. I know they are looking down on me and us today, and I hope we and I can honor their legacy. But over a century after they arrived in Los Angeles, I find myself needing to do the honorable work of pursuing housing justice for Black people and economic liberation for Black communities under many similar and some dissimilar circumstances. As a 28-year resident and renter in Leimert Park, our Africa town, for the last 15 years, I've led advocacy and policy work that is focused on just communities and the impact of state decisions on the traditionally Black and brown community of South Central Los Angeles, with a hyper focus over the past 5 years on gentrification. If we could go to slide 3, please. Next slide, please. About power. Malcolm X said revolution is based on land. Land is the basis for all independence. Land is the basis of freedom, justice, and equality. And I will offer commissioners, senator, assembly member, every war in human history has been about land and access to land. Next slide, please. And so as we look towards solutions to the crisis of gentrification for Black people and Black communities, at its root, we have to talk about the current and past harm that has been done through actions and policies and transferring power to Black and marginalized communities, recognizing that Black communities have a right to self-determination, recognizing that the government power, which is currently being used in a different manner, can be used to regulate a racist housing system, recognizing that government power and specifically budgets have to be directed and redirected toward building a reparative and restorative economic system, where among other elements, housing is decommodified and Black families, businesses, institutions thrive, grow, and thrive free from the winds of exploitative and a racist capitalist system. Right now, the power rests in capital, with speculators, developers, banks, and regrettably commissioners, senator, assembly member, the state, with its overt acts of passing harmful legislation and its failure to use its state power to regulate the evils of racialized capitalism, the failure to pass protections for vulnerable communities, failure to pass protections for those harmed by the history of American chattel slavery. Next slide, please. I believe I was brought to this illustrious body to be blunt, so allow me to do so. The state's housing policy as it is today is racist. And every state apparatus, including the Attorney General's office, the governor, the courts, and unfortunately the legislature, continues the sad tradition and morally repugnant history of urban renewal, which James Baldwin appropriately titled Negro Removal. We are now in an urban renewal 2.0, and it is a deliberate man-made attempt to remake the urban core where Black, Indigenous people of color disproportionately reside into a space for more affluent, whiter gentry and remove hundreds of thousands of marginalized and Black Californians from their homes. Instead of calling gentrification in our racialized housing market a policy failure, that is completely inaccurate. We should call it what it is, which is the successful policy, the successful public policy. Gentrification is the manifestation of the coordinated public and private policy and processes intended to create profit for elite investors of harms that are inflicted on low-income, working class, and marginalized people who are disproportionately Black. Noted urban geography Neil Smith's seminal work, Gentrification as Global Strategy, dives into this global process of capital going towards an urban remake a lot more. And activists throughout the country, including an amazing brother who's in DC by Aristotle Teresa, he's waging litigation currently that brings to light documentation that shows how local government is engaged in an intentional process through market rate project approval to change Black communities into those for a more and wider and richer creative class. It is the intent to use state power on behalf of capital, operating within an anti-Black American society and world that we see and much recognize, because only by recognizing this public and private sector cohesive and coordinated anti-Black weapon can we begin to answer the question of what can be done to disarm it and what can be done to repair the harm done both past and currently being done. It is how you can see the frequently referenced false solutions for what they are. They actually serve in many cases to exacerbate inequality and are leading to increase resegregation through gentrification by pushing Black people currently in an urban core out to far-flung suburbs where there is less opportunity, less social infrastructure, and where their social fabric has been lit. We could go to slide 62. And more. Fix 2. Keep going. This is actually from our gentrification 101, or at least this portion, where we dive in for about 8 hours. 62, please. Slide 62.
Give me one moment, please.
No problem. Where we dive into what's taking place on a global scale, the particular American context that puts Black communities at risk, along with getting people to recognize the true actors and solutions. It's actually condensed in its condensed form, 2 4-hour sessions back to back. And I say condensed because it comes from the work of Crenshaw Subway Coalition, Uplift Inglewood, Hyde Park Organizational Partnership for Empowerment, and bringing together and trying to get greater understanding of what's taking place in our community. That was originally a six-week consecutive popular education project where we dove into our own experiences and sought to understand what we were seeing. They're going to do the same here today, hopefully by getting to a point once we get to slide 62, where we see that gentrification is the result of global decisions in capital. 62.
Okay, I apologize. We reordered them for you, and it doesn't seem to be.
Okay, keep going. Oh no, back up. Wow, they're all reordered. No. Okay,
Closer.
yes. There we go. Back a little bit more.
There we go.
Perfect. So who are the actors? Who are the perpetrators? And let us understand why this is a little bit different today than what it was in the beginning. And some of the causes. One of the major driving forces in current gentrification is financial industry deregulation. Banks now are both the source of capital investment, construction bonds, and they hold the mortgage. They're willing to increase the credit of some, particularly speculators, which we'll get into, and those who are more affluent, and are continuing the process of discriminating against, as I think other speakers have referenced, Black people who have the same income and credit scores as white people. With foreign borders falling, we're now allowing into the country a record amount of foreign investment and speculation, where people are looking to park money into what we call frequently vertical safe deposit box, because they are speculating on a return in value in the changing of urban communities. Next slide, please. And so some of the big changes that we're beginning to see on the ground here is that many of the mom and pop landlords that operated those small single family or small multifamily properties are now being owned by Wall Street investors. Many of the corporate actors, or many of the actors who are buying these homes, are not even known to the tenants because they're operating in LLCs with invisible investors. It's been quite well known that private equity firm, among them the largest in the world, BlackRock, are now buying single family homes, and we see what that disruption has done to the market. Less talked about is that they're using public pension funds as part of those dollars to engage in that unsettling of a single family home market. We go into this a lot more, but the investment primarily, we go into this a lot more within our advocacy work, Crenshaw Subway Coalition.org/gentrification101, but they're focusing on the low income market, better known as the starter home market, for a specific reason. We'll get to that. We're seeing that Airbnb is taking housing off of the market that otherwise would be occupied by renters. We're seeing the flippers, and we are seeing, most importantly and most vividly in the work we're doing, the consequences of upzoning and speculative real estate development. Next slide, please. Next slide. And so with this chart, which comes from the Anti-Eviction Mapping Project, we're seeking to kind of get people to understand how the concentration of corporate ownership is in low-income communities. BlackRock is a $8 trillion operation. They could buy homes anywhere on the planet. But they, and entities like them, focus in, and this is the Southern California region, in disproportionately Black and brown communities for a specific reason. You'll see there are no dots, very few dots on this map for Santa Monica or Beverly Hills or West Hollywood. lots in Compton, lots in Inglewood, the Crenshaw community, Glenwood, places where Black people and people of color reside. Next slide, please. In addition to that, you're seeing with crowdfunding that was adopted and allowed through the Jobs Act that was passed by our President Obama, that many smaller investors, not just large global investors, but many smaller investors are now buying some of these single family homes, some of these multifamily properties that otherwise would go to mom and pop landlords who are less likely to engage in nefarious activities to push out the tenants. Here you see, much like it's a stock market, people who are investors and can do so literally from their pajamas in Singapore can buy into and invest into an operation that seeks to buy, and these are rent control properties for the multifamilies because they're in Los Angeles, they were built well before 1978. Buy into rent control properties and take ownership on the belief that they'll get a greater return and a much greater return than would be allowed under the current rent stabilization ordinance. Next slide, please. Next slide. And we're seeing the consequences before previous slide. We're seeing the consequences of, previous slide, please. We're seeing the consequences of rampant rezoning. Upzoning, rezoning, which is well known as problematic in the East Coast, has unfortunately become the conversation and topic of discussion here in California, is creating value in land that the home itself does not have. It is real simple. If you have a home and you can build only one unit on the home, it is sold as a single family home. If that plot of land can then be built for 10 units, then the value of that home increases because it's not based on the value of the property on it, which is already built. It's based on the value of what you can build with the property and change it into. Here's a listing for $1 million home in the mid-city community that used to be actually very racially diverse and is now becoming less so, where you see the realtor specifically saying, this home for $1 million is not priced for a family. It is priced for what is known as a transit-oriented communities project, a redevelopment, and he's seeking investors. We're finding this out as on behalf of our community, we're engaging in small site acquisitions through the Liberty Community Land Trust, where we see regularly references to upzoning, regularly references to transit-oriented communities, SB 9, ADUs, and seeing the value of the homes and the values of the property predicated on that change, not predicated on the value or the rents of the property as they currently exist. Next slide, please. And here you're seeing that in this broad context, while we as a community-based organization would need to go and get traditional lending, those who are engaged in this flipping, who again are targeting and focusing on Black communities, are often doing it with no capital. There are loads of hard money lenders and others that allow you to and provide lots of training on how to buy that single family home or how to buy that multifamily and flip it literally without any of your own dollars. Next slide, please. So why are they focusing on communities like Crenshaw and Compton and other Black, brown, and communities of marginalized people? Again, urban geographer Neil Smith identifies this and explains this through the rent gap theory. The difference between the actual rent, what's actually being paid right now, and the potential rent. These communities, through transit infrastructure investments, the increase of the creative class and directly adjacent Culver City's Hayden track, increase in the creative opportunity in downtown Los Angeles, are focusing on areas where there has traditionally been undervalued real estate, and now, and I'm sure if Pete was here, he would have talked about the criminalization and the dang injunctions that have been used have been, in some respects, made more quote unquote safe, are safe not just for people to reside, but safe for capital to return to. It's only by removing the existing residents, who again are disproportionately low income, Black, brown, that you can realize that new gain. That gap in communities where you're in low income communities is significantly greater than they ever would be in a Beverly Hills or West Hollywood. Next slide, please. And so now we're going to talk a little bit about a specific project and the consequences of this upzoning decision. This is District Square. District Square is located at the intersection, a project that is proposed at the intersection of Obama and Crenshaw, where a former Ralph's grocery store used to be at, but was torn down by the developer. And it was a proposed multi-unit property, 577 units, 100% market rate in the heart of Black LA in the Leimert Park community. The city of Los Angeles has said that to afford a market rate home in South Los Angeles, or market rate home in the city of Los Angeles, you need to make, the family needs to make at least $125,000 per year or more. The median household income for families in the area that surrounds this project is $45,000. Next slide, please. And so after we got wind of this project, the developer who literally was working on it was arrested for bribery. Not for this specific bribery, but for bribing a public official in another engagement. And just to be clear, the person who he bribed has already admitted their guilt. He's just awaiting going to court. So here we have a project that's intended to gentrify our community, a project that has a developer who's literally on trial for bribing a public official and is likely on his way to prison. Next slide, please. And that came at a time where a state law was used to ram the project through. Within 15 days' notice, this total rework of this massive project that was going to unleash an untold amount of indirect displacement and was completely unaffordable to a Black community was to be approved without even a public hearing. Our organization, the Crenshaw Subway Coalition, filed an appeal, and we succeeded in doing something that almost never happens. We were able to convince the Area Planning Commission to reject the project. We weren't only able to convince the Area Planning Commission to reject the project, we were able to get them to do it on the grounds that it would increase displacement, gentrification, and houselessness. We even got the council member to come out and list some quite powerful words in saying that if the current residents of the neighborhood cannot afford the project, it should not be built. Next slide, please. And so to our dismay, a group, a YIMBY group out of the Bay Area known as CARLA, for the California Renters Legal Advocacy and Education Fund, which had pushed the very law that made this quick streamlined approval of this massive market rate project in a low-income community, actually spoke out in support of it. They referenced the Housing Accountability Act, which again has been referenced many times in the public, and people frequently think about typical, more affluent white NIMBYs, ignoring entirely the struggle that we have in communities like Crenshaw to use such methods of organizing and education and convincing our elected officials and bringing the community together to oppose projects that literally can lead to our displacement, literally lead to our death. And so this Bay Area YIMBY group came out of left field and chose this project among hundreds which are heard from. I'm saying hundreds of land use projects are heard from in the state of California. Just to weigh in saying that against the wishes and wills of an organized Black group asserting its right to self-determination with the support of Black elected official, the local Black elected official, it should be approved. Ultimately, after the planning commission had ruled that the project was inappropriate and on gentrification grounds, they were forced to by a court to approve it because it did not comply with the Housing Accountability Act. Next slide, please. And so who was behind this? Ultimately, YIMBY, NIMBY, it's not really about any individual, it's about the power that's behind it. And Peter Thiel is a Bay Area-based billionaire. He's a big tech founder of PayPal and a venture capitalist, a major Republican donor and supporter of Donald Trump, who has a very libertarian belief, who believes strongly in this concept, this fantasy of trickle-down housing theory, that if you just create market rate housing everywhere, it will make more affordable housing. There's nothing in the history of American housing to suggest this. And we can dive deeply into that even more to talk about how the real estate investment and construction market actually operates versus this, frankly, fantasy that real estate investors are social service agencies that are suddenly going to build themselves out of the profits that they're earning. He was an early supporter of YIMBY and specifically the founder of CARLA. And so let's just dive into that a little bit more. Big tech, libertarian theory, using the power of the state to push loans to underwrite and undermine the power of local communities and local municipal entities to determine how development would take place. This is consistent with the pattern of disempowerment that's been going on since the days of redlining. Continue. Next slide, please. And we see this even more overtly. There was a famous battle 2 years ago with SB 827, and it was again put up again in SB 50, both of which were rejected. Where the law, someone mistakenly had let it be known that this law, which was going to rezone a large portion of the state of California, taking the power again away from communities to decide their fate, and it would be, in the case of Los Angeles, most disruptive in South Central. They're admitting that this is a disruptive thing, and already a community of color that, in a Black community specifically, that is filled with marginalized people. So in so many respects, we have to recognize this is intentional. We can't say that these are just, unintended consequences. It is known what happens when bad capital and increased speculation happens in communities that already have been marginalized. Next slide, please. And so we have seen, again, with reference to New York, the effects of rezonings in communities that is disproportionately Black and in communities that are disproportionately Black, that these rezonings are harmful. And we should consider them indeed this new incarnation of urban renewal, one where in the past, slum clearing and blight designations, freeway routing was used to destroy Black communities, but now we're trying to use the power of a quote unquote free market. We're trying to use capital to intentionally strengthen those already in power, to exacerbate inequality and destabilize communities through upzoning, through rezoning, so that we can remake, and I say we in the context of government and society, places where Black people currently occupy into spaces for a more affluent and wider gentry. Next slide, please. Oh, so now we dive into a bit. I know there might be questions. I'll pause right there. There might be questions on the Crenshaw Mall. And I want to just briefly state that, again, I'm done with the slide deck, that project and process, which is the largest developed, or would be the largest development within the city of Los Angeles, was one in which the community said that we weren't going to be gentrified out, that we would come together as a community organization, as a community force, and seek to buy the largest commercial asset in all of Black Los Angeles, and by that definition, one of the most significant commercial assets across America. And what we saw as we negotiated with Deutsche Bank and submitted bids, and often submitted higher offers than the gentrifiers who wanted the project, is that and what we found in that process was that they actually were operating at the behest of public pension funds. Los Angeles County Employee Retirement Association, UC Board of Regents, Los Angeles Fire and Police Pension Fund, New York City Employee Retirement System, New York City teachers, Michigan, State of Michigan employees. They were all investors in a project to gentrify the community. And they were all giving direction to Deutsche Bank, who was deciding whether to sell this major commercial asset, which we wanted to have as a space for community healing and uplift, not uproot, or to sell it to a gentrifier, which they ultimately did, who was backed by speculative capital, seeking to cash in again on that rent gap. There'll be a lot more about that. We're actually working on a civil rights lawsuit right now, pointing to racism in contracting, where they literally rejected the highest offer from us on multiple occasions, engaged in practices where we literally would not be spoken to. The Black people who were leading this would not be spoken to, and the white decision maker on the other side, we had to use white emissaries to relay information to them. They weren't speaking to the Black local residents who were in control of the tens of millions of dollars of funds that would have been required to acquire the project. So I'd love to talk about that a lot more. I know the presentation was to be concentrated. And again, I invite this dialogue to continue. But I also want to say that before I intentionally did not have multiple solutions, because that's a long conversation. And I think that when we talk about the solutions to gentrification, as honorable and able as this commission is, you cannot do it in the hour. And they are multi-pronged. They are deep. The CLBC needs to consider this a critical issue that it goes into. You need to have entire days of experts dedicated to this, because as I said, and as I began with Malcolm's quote, it is land that is the basis of all independence, of freedom, justice, and equality. Thank you so very much.
Thank you very much, Damian, for that thorough and enlightening presentation. So now I'll turn to the task force members for questions or comments and discussion. And just making a note that we're a bit over time, but that's okay. We'll adjust accordingly and make sure to give a break as well. So are there any questions or comments from the task force at this time for our panelists, Daryl Owens, Brandon Green, Zarita Jones, and Damian Goodman? Oh, I have a question for Brandon Green. So is there anything that you can see that the task force assisting with in terms of the legislation that you were talking about earlier, the proposed legislation?
I think yeah, to the extent that the task force is being provided with all of the information about the ways in which homelessness is actually a racial justice issue that disproportionately impacts Black folks, and it has ties to the carceral system and to sort of the economic longevity of Black folks. And the task force is a conduit to carry that information forward to other levels of government. Obviously, Senator Bradford and Joan Sawyer here as well, but I think the task force being a conduit for that information, the information that is presented by the other panelists as well to not only the legislative offices, but to the governor and others is helpful in situating both that particular proposal and other proposals that community advocates are presenting as those that would move forward in terms of a reparations framework to housing, homelessness, and the other issues that were presented, particularly the intersections between those things and the carceral system, and the push out in historically Black communities that are not only have economic consequences, but social and political consequences as well.
Thank you. So I'll recognize Member Grills, but I also want to say that I made that question because we have conversations around low-hanging fruit, and I want the task force we should start considering or thinking about what are some wins, what are some things that we can put into action before, I guess, the end of the process, right? Because we could wait until the end of the process to start developing reparation proposals or taking particular actions, but we can also try to think creatively about how to, pick that low-hanging fruit. What are some things that we can do right now to not only amplify the great work that we're doing in these public hearings, but in the case that we can develop a reparations proposal, before the half of this process is over, and that can go to supporting particular legislation like you suggested. I think those are conversations that we should start to have. Did you want to follow up, Brandon Green? Then
if I could just add one more quick thing, that intersection between houselessness and the carceral system, there's other legislation as well. I'm part of the Debt-Free Justice Coalition, which over the years, first with Holly Mitchell and then with Senator Skinner and others, Senator Bradford last year, have been successfully pushing legislation to get rid of criminal administrative fines and fees, for example. Those are the sorts of fines and fees that accompany the criminalization of homelessness. So, Lawyers Committee last year put out a report about non-traffic stops and how disproportionately they impact Black people, and disproportionately impact unhoused folks. These are quality of life citations, for example. And those are the sorts of things that are at this intersection. That is also an area of legislation that the task force or individual members of the task force could support as well. So I just wanted to make sure that I added that.
Member Reggie Jones Sawyer, Bradford, can you remind us, when does the California legislature reconvene? and then we'll go to Member Grill.
January 3rd.
Okay, thank you. Okay, Member Grills, you're recognized.
Okay, thank you. I want to thank the panelists who presented this afternoon on a topic that we don't hear enough about. And my question can go to any and all of the panelists, and that is, what reparations strategy should the task force prioritize to move the needle in a substantive way around issues of gentrification and houselessness? And then also, is anyone tracking the quality, the consequences of gentrification and houselessness on the quality of life, health, mental health of Black folks?
I have ideas, but I just spoke, so I don't let the other folks speak first if they have some.
Well, I can dive in. I guess the framework again is about power. If you are engaging in policy that seeks to empower those who are already doing harm, you're not going in the right direction. So how do you transfer power to Black communities? The best example of a community, and it's within every urban planning school's syllabus across America and some across the world, is that of Dudley Street Neighborhood Initiative, where the state actually transferred eminent domain power to a community-based group. One of the first executive director of that is actually on our board for downtown Crenshaw Rising, and actually lives in Leimert Park, and his family was one of the first people in Leimert Park. And so he reminds me that simply having that power, he never had to exercise it. But the threat of it allowed absentee property owners who were using the Dudley Street neighborhood in Boston as a dumping ground to sell to the community, which now is under community control and being used as a means to heal lots of social ills. It's a holistic program that the Dudley Street Neighborhood Initiative is. So there's a similar action, or just talking focused on eminent domain here locally, where the Hillside Villas, this is within Chinatown, is dealing with the lapse of covenants, affordable housing covenants, and is asking the city to exercise its eminent domain power to acquire the building, stabilize the tenants who otherwise would be pushed out, because the covenants are now lapsing, the rents can now go to market. You can dive into a whole history and need for transferring power from landowners or property owners who own multifamily housing to renters. There is no existence of actual rent control in the state of California, which is why we've seen formerly strong Black cities like Oakland literally become unaffordable overnight because of vacancy decontrol, whereby when the tenant is either pushed out or voluntarily leaves, the rent can go to market rate. Vacancy control, which was adopted in very few places in California prior to the adoption of Costa-Hawkins, actually had a city that is now currently completely unaffordable, Santa Monica, be an affordable and mixed income city. But the absence of it has now made it into one of the least affordable cities in all of Los Angeles. Again, power. That power is now with those apartment owners and not with those tenants who in the state of California are disproportionately Black.
I would say, I meant to mention this in my testimony, but neglected to, that only 1 in 4 eligible households receive subsidies, housing subsidies, for example. And because we know who is disproportionately rent or severely rent burdened in jurisdictions, like that's an area, obviously, housing subsidies are federal, but there's no reason why California couldn't have or create some sort of similar program, right? And I think this intersection of the carceral system is an important point, because folks exiting the system are severely at risk for entering homelessness, right? So the way in which we create services for folks, subsidies for folks exiting incarceration is important. And then because of the cost of just existing in California, in the Bay Area in particular, that also then is going to dovetail with um, access to higher income wages and jobs, for example, because we know that, for example, in Oakland, even if you make minimum wage of $15 an hour, like you're not going to really be able to afford a 1 or 2 bedroom apartment there, or almost all of your income would go towards that. And because while there's been work done in terms of the barriers for access to jobs for people exiting incarceration, like those barriers are still there, and a lot of those jobs are not paying enough to be able to afford to rent an apartment, which then puts folks at increased risk. And some of these other things around, the criminal fines and fees, as I said, they become an albatross for folks is important too, because those are severe wealth extraction policies that, while race neutral on their face, are targeted at Black people through racialized policing and other things. And because Black folks are overrepresented in unhoused communities, and unhoused communities are overrepresented in those targeted by police, and that intersection of race and houselessness becomes a contributing factor that makes it more difficult for folks to be able to exit homelessness, for example.
And then we'll close out with Vice Chair Brown.
Thank you, Madam Chair and members of our task force. I'm sure I'll voice your sentiment collectively to say that we are very much informed and inspired to see homelessness in a light that we have the moral obligation to hear and to heed what they've said, in order that we might include their concerns in our priorities as a task force. Thank you so much for what you shared with us. And Brother Damian Goodman, did I understand it correctly that you are the descendant of Colonel Allensworth?
Great-great-granduncle who was married to Nella Allensworth, his daughter.
Well, you are a reincarnation of his spirit. Do you know he was also pastor of the Union Baptist Church of Cincinnati, Ohio, during the days of Reconstruction. And he succeeded one Charles Satchel, who came across the Oregon Trail in 1856 to be the first African-American pastor of the historic Third Baptist Church of San Francisco. And the peculiarity of all of those faith leaders was that they had more than going to heaven on their minds, but they were all fighting to enjoy having a piece of this good earth. And you know, Vernon Johns, who preceded Dr. Martin Luther King Jr. at Dexter Avenue Baptist Church in Montgomery, said once, if you want to see a classic example of perpetual motion, sell a Cadillac car to a Black man and tell him to park it somewhere. Well, thank God, your great-great-grandfather, uncle that is, was not in perpetual motion. He made every effort that could be made for us to have that town, Allensworth, where he envisioned the replication of Tuskegee in the Western United States. But again, because of oppression and the meanness of a racist society, that community was never realized. And we ought to include that Senator, in this reparations plan, restoring the town, Allensworth. So it makes me happy to see you and that you have the spirit of your ancestor.
Thank you so much, Vice Chair Brown, for those closing powerful comments. I want to take this opportunity to thank on behalf of the task force, Brandon Green, Daryl Owens, Zarita Jones, and Damian Goodman for your incredibly thorough and powerful and inspiring testimony on the issues of homelessness and gentrification. And we look forward to continuing this conversation, staying in contact with you all, and building upon this work.
Thank you.
So, thank you. So, recognizing we're a bit over time, I wanted to turn to the task force for insight. Would you all like to do our break for 5 to 10 minutes, and we can decide what time frame we want to do that, or should we go straight to the outline portion of the agenda? Any comments or like strong inclinations for what we do? Should we do a break? I think we should take a break. I don't know. I think a break is good. So we'll reconvene. We'll take a 10-minute break. Yeah, we need a break. So we'll reconvene at 3:40, 3:40-ish. Okay, thank you.
Let me call you as soon as I get in the car. I'm just walking. I'm right here now. I'll call you right back. Okay.
Okay. The time is 3:40, so we will reconvene the meeting. But before we reconvene, I will turn to Parliamentarian Johnson so that she can establish a quorum. Parliamentarian Johnson?
Yes, Madam Chair. I will call the roll. Chair Moore,
Present.
Vice Chair Brown,
Present.
Member Bradford, gotcha. Member Grills,
Present.
Member Holder,
Present.
Member Jones Sawyer,
Present.
Member Scott Lewis,
Present.
Member Tamaki,
Present.
Member Montgomery Stepp, Member Montgomery Stepp. The task force consists of 9 members. 5 members are needed for a quorum. There were 8 members present. Madam Chair, a quorum has been established.
And Ms. Johnson Bradford just vocalizing present for you.
Thank you. I did check. I have you. Thank
Great,
you.
thank you.
Thank you very much, Parliamentarian Johnson. So it was important that we establish a quorum, particularly for this section of the agenda, because the task force must vote to authorize the staff to proceed with drafting the report. And for the purposes of this conversation, we're going to, well, I'll take suggestions, but I was going to just give a brief introduction of each section of the outlines in which we've received. And then we can have a conversation based on each of those sections. So one at a time, essentially. And then we can take a vote one at a time, or we can wait to vote towards the end. I think for purposes of clarity, I think it might be helpful for us to just take each section one at a time. And then we can, take separate votes. But if anyone has any other suggestions, that's fine too. So in preparation for this meeting, I asked the California DOJ staff to create section introductions or blurbs based on each section of the report outlines that we've received. Partly just to remind us as task force members of each of these sections and what the overview of each of these sections are, but then also to educate the California public and remind the public that not only are we hosting these virtual public hearings, but we're also in the process of creating a 2-part written report. And we have received outlines for 12 sections, and those 12 sections will consist of our first written report. And then after we authorize the California DOJ to proceed with these outlines, then they'll give us additional reports for section 2 or report 2. So again, just to summarize, we are going through each of the 12 sections of the first written report draft outlines, and we're having a discussion about any key takeaways that we want the California DOJ staff to adhere to as they continue to draft the report. So for the first section of our first report is a section on slavery, and it was written by Professor Stacy Smith. In the interest of time, I'm not going to be able to read the entire blurb that the California staff wrote for the purposes of this conversation. So I'll just say just a few key points from this section for the benefit of the public. So the first section of this report on slavery, Stacy Smith is helping us to write on the institution of slavery and the enslavement of people of African ancestry in colonial North America and the United States from the 1500s to 1865, as well as the aftermath of emancipation during the Reconstruction period. She will also, in the report of this section, there's also just a discussion on slavery in California and elsewhere. And yeah, I'll stop there because there's a lot that I'm really conscious on time, so I don't want to read the entire blurb. But the task force members are aware, we're all aware of the contents of the outline. So I'll stop talking now and turn it over to the task force. And going through and reviewing section 1 on slavery, were there any points that we wanted to raise to the California DOJ about this particular section?
Madam Chair.
Yes, Vice Chair Brown, you're recognized.
I'd like for us to consider as an entitlement, we will not use the phrase slavery, but enslavement. Because what happened to us, it was done by force and by legal public policy. It wasn't like as it was in ancient times, that people were, because of their doings, were indentured servants or enslaved. This was an organized, systematized, legalized enslavement coming from the hand and the minds of people who were just downright evil. So it was enslavement.
Yes, thank you, Vice Chair Brown. That's actually something that I wanted to raise as a suggestion for the next batch of outlines. I'm sure everyone knows about the 1619 report. Nicole Hannah-Jones, she was recently on a podcast, I think through NPR, and she said that she created a language guide for the 1619 report to make sure that all the language was consistent. And so, for instance, to Vice Chair Brown's point, in the language guide, she pretty much stated, all the writers that are going to be involved in the 1619 project don't refer to enslaved people as slaves, refer to them as enslaved. Don't refer to plantations as plantations, but to forced labor camps, things like that, to be very intentional about the types of language that we're using. And so I thought that was very informative. And, if we could apply something similar where we're being, as intentional with the language that we're using in this report to make it as groundbreaking and as truth-telling as possible. I think that would be a good point of order. Did anyone else have any comments? Member Tamaki, you're recognized.
Along a similar line as Pastor Brown and you, Camila, I mean, Japanese American redress and reparations went through the same thing. The government had called the mass incarceration as first relocation, and then evacuation, and then assembly centers rather than military style detention camps, internment instead of incarceration. So it does have an impact on the public, I have to say. The words matter, and so I think that's a great idea.
Madam Chair, point of information, are you going to ask for a motion to make those corrections in this report and then going forward to have some consistency with respect to the language?
Yes, I think we're taking global comments about section 1 on slavery. We're having a discussion about just any global comments, and then we'll take a motion after that discussion. Oh, Member Reggie Jones Sawyer, you're recognized.
I'm not wedded to any language whatsoever. I just want to make sure we don't become exclusionary. That we just don't look at as the individuals that went through the Middle Passage that came here. In addition, we had peonage, where Black men mostly would be sent to prison and put in prison camps to do work for white after we were emancipated. And so in a lot of ways, we were chattel to white businessmen in the 30s and the 40s and the 50s, in which eventually peonage was eliminated. But I just want to make sure that we don't narrow it to a point. I like the fact that hopefully that term enslavement expands it so it takes in every type of grievance that we can put up to ensure that we can get the maximum from reparations, or that we can prove the maximum for reparations, and that whatever title we use doesn't preclude us, and this may be the lawyers that need to get involved, doesn't preclude us from being able to do things. We in the legislature, we argue about things all the time, like, will or must, shall or will. I just want to make sure we are intentional, and our intention is to make sure we don't exclude any type of wrong that our people have suffered.
Enslavement is under that umbrella. It's all the same, wherever it happened, even with the vagrancy laws, where they arrested our people and put them into that evil system of peonage. Sharecropping.
Good. Sharecropping is another good example, right?
Member Holder, you're recognized.
Sorry, excuse me.
Yeah, along those same lines of what Member Jones Sawyer was articulating, I think we've already received the outlines and reviewed them, but the outlines are just still the draft form. So my recommendation is that, going forward, we think about some of the testimony that we got today, that we heard today about, about framing this in terms of wrongdoings, wrongdoers, in order to anticipate some of the legal challenges that we might get down the line, to make sure that our analysis is strong and can withstand public and judicial scrutiny. So to the as this is being drafted, I really think some of what we heard about framing the legal analysis should be incorporated into the way we draft this and some of that language as well.
Member Bradford, you're recognized.
I'm sorry, I stepped away again. So are we discussing now the definition, or how do we describe who's entitled? I'm sorry, I stepped out for a minute. Just want to be
That's
clear.
okay. So we're having a conversation about the draft outlines. So we're having the conversation based on each section. So right now we're on section 1, which is on slavery. But for the interest of time, rather than voting on all of these directives, I think we can just agree that the California DOJ staff will do all of what, you know, we're directing them to do. So they're listening intently to this conversation. So for instance, we're on section 1, which is on slavery. We've heard from Vice Chair Brown about, you know, not using the word slavery, but enslavement. You know, we've heard from Member Holder about ensuring that we're kind of inputting into to this report language around wrong-based harms to anticipate any legal challenges. And then I also had me and Tamaki had a similar conversation with Vice Chair Brown about like being intentional about the language. And I even want to ask if, you know, it would be helpful to form an advisory committee of some sorts to develop like a dictionary of like of language that we would want to use for this report. And then we can ensure that that final report utilizes that dictionary. That's just something that I'm throwing out there. So that's where we are. So are there any other global comments about section 1? If not, we can go to section 2. So Member Gross, you're recognized.
Just along the lines of words matter and languaging is important. I had similar comments in my review of the outlines about the word slave and slavery. But I also have a concern with the use of the phrase slave trade. And I would encourage us to use a different term, because in fact, that dilutes what was actually happening. It was not a bona fide trade that was going on. And I think that minimizes the cruelty and the deceit in the process that was happening. Human trafficking and a whole bunch of other terms come to mind, but it was not a trade. And I'm not sure when you're referring to section 1, because if that includes the component on, no, I think it doesn't. I'll leave it at that. I have a concern on another area, but it's not the institution of enslavement.
Member Scott Lewis.
Thank you. I just want to follow up on Dr. Gross' comment and say that I agree with that assertion and the spirit of the conversation so far. But I would argue to kind of keep the trade and then add the trafficking, because in naming it as a trade, it makes clear the foundational role that slavery had for Western European and North American economic foundation. So we have to kind of maintain the kind of economics of the process. And I think, you know, losing track of that can somehow undermine, I think, some of the longer term arguments that we're making. Right? So in other words, the slave trade or the trafficking and the trading of trafficked people is part of this longer trajectory where we see the dispossession, right, of Black neighborhoods in Oakland as being a part of the same process of economic development for the state of California. And so I think it's important to kind of keep that language, but also make it more complicated.
So the first section of the report is on slavery, and the second section of the report is on racial violence. So Member Gross, did you want to make a comment about the institution of slavery, an additional comment before we turn to section 2, which is on racial violence? Okay. So,
Madam Chair,
mhm.
I
Vice
thought,
Chair.
I thought we were going to come to some consensus and use that universal language with enslavement that would encompass all the other call-outs that have been enumerated. If we could make that official, I'd like to make a motion.
Okay, yeah, that sounds good. I offered the idea of an advisory committee to help develop like a language guide similar to what Nicole Hannah-Jones discussed, what she used to create the 1619 project. So, I can volunteer to be a part of that. Vice Chair Brown, did you want to create a motion regarding something like that?
I shall move.
Is there a second?
I'll second.
So it has been properly moved and seconded that the task force creates an advisory committee. An advisory committee is 2 members, if I'm correct. The subcommittee would be more than that. So an advisory committee to help create a dictionary or language guide that will then be used to create the final report. Is there any discussion on this matter? Would anyone else like to volunteer to be a part of that process? I can also get it started. Oh, okay. Member Reggie Jones Sawyer. Okay. Is there any other discussion on this matter? If not, I would like to turn to Parliamentarian Johnson so that a roll call vote can be established. Parliamentarian Johnson.
Yes. Can you hear me?
Yes.
Okay. Thank you. Chair Brown? I'm sorry. Chair Moore?
Aye.
Vice Chair Brown?
Aye.
Member Bradford?
Aye.
Member Grills?
Aye.
Member Holder?
Here. Aye, sorry.
Thank you. Member Jones Sawyer?
Aye.
Member Scott Lewis?
Aye.
Member Tamaki?
Aye.
Member Montgomery Step? Madam Chair, there were 8 votes cast, and there were 8 yeas, and 0 nays.
Thank you. There were 8 yeses, so the vote carries, the motion carries, excuse me. So now that we have moved on from section 1, which is a section on slavery, and we came out with an action item to establish an advisory committee to help solidify the language for the final report, we'll now move to section 2 of the report, which is on racial violence. And this was written by Edward Nugent. As a quick overview, the racial terror section addresses the history of violence and terror inflicted upon Black Americans through centuries of U.S. history, starting with slavery and continuing through Reconstruction, Jim Crow, the Civil Rights era, and present day. The section also highlights the particular history of racial terror in California. So in addition to prominent examples of racial violence in California, the section explains the history of the KKK in Southern California, the Central Valley, and the Bay Area, how the state government and local government supported and enabled racial terror, and how this history of violence continues to harm Black Californians and Black Americans today. Were there any global comments about this section in particular that the DOJ can use? I thought this section was pretty good. Straightforward. If not, we can just power along because I know some folks have comments for other sections. So now we're just going to power on to section 3 of the report, which is on political participation. And this was written by Deborah Tran. So as a quick overview, the political participation chapter discusses the ways that federal, state, and local governments have suppressed Black political power in the United States historically and to this day. So much of the chapter focuses on the right to vote and the various methods used to deny that right to Black Americans, including poll taxes, literacy taxes, grandfather clauses, racial gerrymandering, all-white state primary elections, and other instrumentalities. Are there any global comments on this section in particular? And I just want to remind the task force that we have some of the DOJ staff authors here that are able to answer any questions directly if needed. Okay, we can power through if there's no questions on this particular section. Okay, so the next section is section 4, which is a chapter on housing, which was written by Siu and Yang. So as a brief overview, this housing chapter will cover instances after the Civil War where federal, state, and local government officials working together with private individuals actively segregated American land into Black and white neighborhoods. This housing segregation occurred over almost 200 years and through a variety of different government strategies and policies. These government actions were intentional and they supplemented and intensified the actions of private individuals. Are there any global comments on this section? And let me know if I'm going too fast. I know the outlines we have are over 500 pages and yes, Member Groves, you're recognized.
I didn't have my hand up, I think.
Oh, sorry, Member Holder.
Yeah. You know, this report is so comprehensive, so I don't want to be nitpicky here or just parsing it apart too much, but there's just a couple of areas that I would like some exploration on that I didn't see, and maybe they were even there and I missed it, but with respect to housing and the history of housing exclusion, etc. I'm wondering if we can have some discussion or some explanation of policies and practices like blockbusting, sundown towns, and white flight. You know, some analysis that is specific to those policies, practices, and harms.
Can you expand on that a little bit more, Member Holder?
Yeah, and again, this is a massive report, so I might have missed it. There may have been some reporting on certain practices around housing historically, housing segregation and housing discrimination historically that I missed. But there were some prevalent practices that went on in the state of California and other states to create segregated housing and to, you know, push Black people into ghettoized spaces. And a couple of those that come to mind are practices like blockbusting, which was a common practice. Practices, dynamics like white flight, you know, and the existence of, you know, exclusively white spaces that terrorized Black entry in those spaces, like sundown towns. And so I'm asking if we can have a little bit of analysis. Those are just 3 that come to mind quickly, and I did not see an explanation of those dynamics or those practices. So I'm specifically asking if we could talk a little bit about sundown towns, block busting, and white flight in this report.
Thank you very much. Vice Chair Brown? Oh, Michael Newman, did you want to respond, or if not?
Now, there was a devaluation of Black properties too. That aspect is not there. And that's caused us not to have an increase in our wealth.
I
Michael
was just
Newman.
going to say, sure. Thanks, Chair Moore. I was just going to say, I didn't know Member Holder. Now, obviously, we're hearing these comments and we're paying attention, as Chair Moore has mentioned. We're hearing all these comments, and we'll be working to incorporate all of the recommendations. When you were saying you wanted to have the discussion, are you saying you wanted to talk about it right now? We're presuming you mean included in the report, and we will take these comments and follow up.
Precisely.
Thank you.
Member Tamaki, Member Grills.
So maybe I'm overstating this, but I think the sundown towns may be covered in the racial terror part. Pretty sure block busting and housing discrimination in the form of restrictive covenants and white flight, devaluation of Black properties. I think the material is in there. Now, whether it's sufficiently detailed is another question, but I'm pretty sure, in reading it, exclusively white spaces. I mean, there was discussion, for example, out of state, like Levittowns, but also developers within California that intentionally excluded Blacks from suburban developments. So I think it's in there, but it may be that members would want more detail, but it's not as if the subject is omitted.
Yeah, and as I said, this is a massive report, and so so I apologize if I'm mischaracterizing it by saying certain things are missing. I think maybe the process that we can use is something similar to the glossary that we were talking about, where certain terms and terminology that is popularized is reflected in the analysis. Because what I imagine, I'm thinking about this very practically, is that scholars, the public, eventually are going to be looking at this report, and they're not going to be able to read all 1,000 or 2,000 pages. They're going to be maybe interested in a certain subject, and maybe if there's a popular term like blockbusting, right? That's one way. That's one way for people to be able to find subjects that might be of particular interest. So then my recommendation would be, if the analysis is there, think about some of the popularized terms that are easily recognizable that will help people find their way through this report, and maybe incorporate some of those popularized terms. It's more of a curating language thing that I'm talking about.
And I was just going to add, similar to Member Tamaki, that there is mention of sundown towns in the housing section in batch 1 outlines, but it is a brief paragraph, and it really doesn't go into detail about how sundown towns operated in California. So to your point, more analysis could definitely be done there.
Yeah, and I also have a comment, and this applies to the political participation in housing sections, but more so on the housing sections. And it's a language issue too. So to the extent that we're using Black and brown or people of color, like it would be great to be as specific as possible about like which community of color, which communities of colors, right? If we're talking about all Black Americans, who's descended from chattel slavery, let's be as specific as possible with that. But when we talk about brown, like to the extent that there's research available, and there is, right, in connection to the report that we're making, if we can like be specific, like are we Mexican American communities, Central American communities, I don't know, something a bit more empowering all around, and less kind of generalized language, I think that would be great. But we can discuss that during our advisory committee that we're going to establish. Okay. Are there any other questions on the section on housing? And I'll give people a minute to, look through the outlines for this particular section, because it is a bit long. So I'll just give people like a minute. I'm giving myself a minute as well. Okay, so if there aren't any other global comments around housing, we can go to section 5 of the report. Section 5 of the report is on the environment, and this was written by a staff member, Brian Bilford. So in brief, this section discusses the legacy of slavery, Jim Crow, and government redlining policies that have imposed environmental impacts which harmed and continue to harm Black Americans. Are there any questions, comments, concerns about the environment section? And again, I'll give the task force member some time to look through their comments on this section. Okay, I thought this section was very comprehensive. It detailed harms throughout the state of California, and talked about historical and present day harms as it relates to environmental racism. So this section was great to me, making a global comment. Okay, if there aren't any other global comments about the environment section of the report, I'll turn to section 6, which is on education, and I'll give task force members a minute to review their global comments on the education section. And as a quick overview, this section was written by Laura Fayer, and it discusses how the quality of education is a foundation for a good job, for building wealth, and in the words of the Supreme Court of California, for the preservation of the rights and liberties of the people. Yet it shows through this report how the government of the United States of America at all levels, and including that of California, deprived generations of Black Americans of the benefits of an education. Are there any global comments that task force members would like to share on the education section of this report. And again, I'll give task force members a minute or so to look through their comments, their past comments. The only global comment that I had was that I wanted to see a discussion of James Anderson's book, The Education of Blacks in the South, a more robust discussion, because I think that ties directly to our conversation around the Great Migration and the impetus and implications of the Great Migration. But that is it for me on that particular section. If there aren't any other comments on the education section, we'll move right along to the health section, which is the 7th chapter of our report, which was written by Roop Singh.
I think Dr. Wilson had comments on the education.
I just have, yeah, thank you. I just have one comment related to the education section. I recommend an addition of a section that focuses on the issue of the misalignment between the culture and ethnic racial background of the teacher and the student, and also curriculum deficits in the curriculum in terms of Black students of African ancestry not seeing themselves reflected in the curriculum. And that has a direct impact on academic achievement, on sense of identity, on sense of belonging in the school. And there's a literature around that. And I recommend, I gave some content and also recommended a couple of scholars to cite in that regard.
Yeah, and as far as additional information, hopefully I didn't miss this, and I don't want to mischaracterize the report, but I think it would be helpful to have a discussion within the report about disparities, continuing disparities that we see in expulsion and suspension rates of African American youth, the adultification of Black girls in school, and you know, and some more information on the school to prison pipeline and the push out of Black girls and boys.
Great, thank you for that. So the next, if there aren't any other comments on that particular section, we'll move on to section 7 on health. As a quick overview, this section of the report delineates or discusses how the United States has treated Black Americans as subhuman, destroying the health of Black communities through racist oppression, torture, sexual violence, abusive experimentation, forced labor, and harmful neglect. More contemporarily, this section of the report also discusses how Black American women face higher rates of maternal death and adverse birth outcomes, how Black American children face disproportionately worse health consequences in school, criminal justice, and the foster care systems, and how the mismanagement of public health crises by the state and federal governments has resulted in adverse health consequences and disproportionate death in Black communities, particularly during the COVID-19 pandemic. And so this particular section ends with the statement that California owes health-based reparations to Black communities for institutional racism in healthcare, racist health laws and policies, eugenics, harmful experimentation, over-incarceration of Black Americans, and racist neglect of Black health. Health-based reparations for Black Californians are essential for the future of California. Are there any global comments about the health section of the report?
I would like to speak, Chair Moore.
Yes, you're recognized, Member Gross, excuse me.
So I'm still not finished with this section, so my comments are in that regard, but I really want to encourage us to not lump health, public health, and mental health under one umbrella, because then the mental health issues are so overlooked when it comes to understanding the racial terror and trauma that we experience, the ongoing racial oppression, racism that we experience, that to lump mental health up under the umbrella of health in general and public health kind of mitigates against us paying the right. Yes, you can. Sorry about that. My grandson came over this afternoon. Okay, sorry. But in any event, I really would encourage us to, at least in the heading, to put health and mental health. And then we can stay with the sections under that where we clearly give due attention to mental health.
Okay, great. Any other comments for this section? Okay, if not, we're going to turn, did I miss anybody? Okay, so we're going to turn to section 8 of the report on family, which was written up by Brian Bilford. So a quick overview, this section discusses how for over 400 years, the federal and state governments of our country have systematically decimated the Black family. They have done this both through official government action and apathy, as well as through the creation and support of racist policies and practices of private actors. So this section of the report discusses child welfare agencies and how they've targeted Black families for investigations and for removing Black children from their families at much higher rates than white families. And it also discusses how Black families are disproportionately targeted, particularly Black men and Black children, for punishment. All of these actions have caused well-recognized and devastating harms to Black Americans. Any comments on the family section? Okay. So hearing no comments on the family section, we'll go to the 10th section, which is on labor, which was written by Lisa Elrich. Again, as a brief overview, this section of the report will tell the story of Black Americans in the United States and how it begins with labor. First, as the purpose of slavery was to harness the labor of enslaved persons purely for the benefit of others. But then it's also going to discuss, right, Black codes, Jim Crow laws, how Black Americans were relegated as an underclass by restricting their access to labor markets and economic freedom. It's going to talk about how Black Americans have historically had more limited job opportunities with corresponding limits in pay and ability to provide for their families and build wealth. And are there any comments, global comments about this section in particular on labor? Okay. So hearing no comments on the labor section of the report, I'll go to section 11 of the report, which is on the justice system. And this was written by Francisco Valderrama. As a quick overview, section 11 on the justice system will discuss continuous actions by government officials to treat Black Americans as inferior throughout American history, which have resulted in inequities in nearly every area of the criminal and civil legal systems. So it'll discuss how Black Americans have historically experienced marginalization, torture, and murder at the hands of the criminal justice system. But then it'll also talk about the effects of slavery in the civil justice system, particularly surrounding the reality that Black Americans, particularly those with low incomes, experience several systemic problems in the underfunded court systems, both nationwide and in California, that prevent them from accessing justice in the civil courts. Are there any comments, questions, or concerns about the justice system section of the report? Okay, hearing no comments or questions, we'll move to the last section of the report, which is on wealth accumulation, and this was written by Sri Panchalam. So as a quick overview, this section of the report on wealth accumulation will discuss how racial wealth inequality remains a persistent defining American issue and is not accidental. It'll discuss how the United States has systemically prevented Black American communities from building, maintaining, and passing on wealth because of the atrocities of slavery, segregation, racial terror, and institutional and systemic racist suppression. Are there any comments on the wealth accumulation section of the report? I did have a comment on this particular part of the report. So I noticed that this section had a standalone section for Black women and the impact of racist wealth building as it relates to Black women, but I didn't see a comparable standalone section for Black men. And so I didn't understand why that was the case. But if there's going to be a standalone section that discusses wealth building as it relates to Black women, I think it's only right and fair for there to be a standalone section for Black men, and particularly, and I put in my track changes, in the comments in my track changes, there are some pretty amazing scholars like Tommy J. Curry. He's like one of the founders of what's called Black Male Studies, and he wrote a book called The Man Not, that really discusses the positionality of the Black American man in the United States. So I would like to, if we're going to have a standalone section, that talks about Black women versus Black men in terms of wealth building and capacity. I think if we can call on Dr. Curry and Black Male Studies in his book The Man Not, that would be great. But then also I noticed what was something that was missing in the report, which is missing in a lot of reports like this. And it's that, for instance, a lot of reports don't, when we're talking about labor, employment, and wealth building, a lot of these reports do not include the incarcerated when we're having conversations about employment or unemployment. Usually the incarcerated are considered invisible and they're not counted. So for instance, and I can pull up the particular part of the report, but it's not necessarily necessary at this time. My major comment is just that, for instance, if you count the amount of Black men who are incarcerated in this state, who then are now essentially slaves, they're enslaved by the state, making cents to the hour. If you actually bring in that data, you would find that in many instances, Black men get paid less than Black women. But when you take those that data out of the equation. When you render the incarcerated invisible in that way, you'll get a common stat that, Black men get paid higher than Black women, which is true in some particular ways, but in other ways, that is definitely not the case. And so in my track changes, in my comments in the track changes, I sent some reports from not only Dr. Tommy Curry, but from the Brookings Institute that talks about this phenomenon. So I would love to see information like that reflected in the report to make sure we're being as comprehensive as possible. Are there any comments or questions to that, or any separate comments related to this section in particular? Okay, so if not, there's something else that I wanted to raise, but I'll just alone. Oh, Member Tamaki, you're recognized.
Are we missing arts, culture, and entertainment? Do we cover that section? I thought that was.
Yeah, that's something we're supposed to go through, but I didn't receive a blurb about that from DOJ staff. So thank you for bringing that to my attention. We can just have a conversation about it.
Madam Chair, I'm sorry. I have a real hard stop. It was at 4:30 and I got to take off. So I'm probably gonna have to miss this vote.
Okay, thank you, Member Bradford. We'll see you in the next
Madam Chair,
Yes.
the culture is at the top of the next page.
Okay.
Section 9 is at the top of the next page.
Oh, I see. Okay, thank you for that.
Okay. You're very welcome.
So now we'll return to the arts and culture section, arts, culture, and faith, which was written by Roop Singh. So as a quick overview, this section of the report will discuss the history of the United States, the federal government and state governments having, promoting, and generating cultural and artistic narratives that reinforce racist stereotypes about Black communities. Yeah, and so it also has a discussion around how the state of California in particular has actively discriminated against Black American artists, culture makers, and people of faith. It also discusses how the state has neglected to protect Black American artists, culture makers, and people of faith from discrimination, and ends with a call for reparations for historical discrimination in arts, culture, and faith. Are there any comments on this particular section of the report?
Madam Chair?
Yes.
The hotbeds that gave growth to our artistic expressions have been destroyed. And specifically, the Harlem of the West in San Francisco. That stands out historically. But through gentrification, through economic deprivation, it has been virtually destroyed. I go back to my pet phrase, there's no watering hole here. Everybody else can go where they can get their cultural thirst quenched, but not for us.
Are there any other comments or questions about this section?
Yeah,
Member Scott Lewis, you're recognized.
Yeah, I'd like to encourage a discussion about the capitalization of Black cultural creation. It's not just from a discriminatory basis, but the way that Black cultural items are being used and capitalized on by these various industries.
Yeah.
Okay.
muted.
Was there a question about arts and culture, an additional question? If not, I wanted to return to the family section because I wanted to raise a question to the task force members. So there's a section in the family section that talks about like intramural or intercommunal violence, so to speak. And so I'm raising the question if you all think that, you know, that type of conversation should be in this report. And, you know, this isn't something that we have to, you know, talk about now, but, you know, it was something that I saw when I was reading through the section, and it didn't necessarily make sense to me for there to be like an in-depth conversation about issues of domestic violence and intimate partner violence in a report about reparations from the state. But I could be wrong about that, so I wanted to hear from other task force members about that. And again, this is something that we can resolve or discuss later, but I wanted to bring that up as a concern for me before we conclude.
So I'd like to make a brief comment on that. It depends on how it's framed, and I don't have that held in my brain, so I'm gonna have to go back and look at it. Depending on how it's framed, it could be relevant. For example, if it is to demonstrate the damage done to one's psyche and mental health and behavioral health because there is quote unquote adhesion to the oppressor or there's internalized racism, then that is a way to demonstrate the harm done to couples and families as a result, psychologically, as a result of the legacy of enslavement and post-enslavement oppression tactics. So I'll need to go back and look at it again and see how they framed it.
Okay, thank you. That works great. That's the comment that I made. I didn't say that this section should wholesale be discarded. I just wasn't satisfied with the current framing and thought that it should be framed in a particular way in order for it to make more sense. You know, tying it to, like you said, like the legacy of slavery and things like that. So I definitely agree and look forward to your comments after going back.
I would say something. I would also say something similar about the arts and culture. I know it's just in draft form, but there needs to be more of a synthesis here, where we are connecting the dots a little bit more about how, you know, the negative imagery, the stereotyping that we're seeing in film and other media art forms, you know, how it is connected to perpetuating the colonized mindset, anti-Blackness. You know, just something that brings it a little bit closer to the present day and the anti-Black narrative that is a continuing narrative. So I would just recommend that sort of synthesis in the arts and culture. And a discussion, a little bit more of a discussion of social media in that context.
Okay, great. Thank you all very much.
I think Dr. Brown has something.
Oh, Member Brown, Vice Chair Brown, you're recognized. Mute Vice Chair Brown. Or is he on the phone? On the phone. Okay, so in the interest of time, like as I said, rather than voting on all of these directives, we can just agree that the DOJ staff, which, you know, they've been intently listening, will do, you know, all of what we're directing them to do in this conversation, and they'll follow up accordingly. And then again, we voted to create an advisory committee to help solidify a language guide that will be implemented through the final report. So thank you, members of the public and the task force, for your hard work and your diligence in getting through this agenda today. We are almost done. I promise. The last two parts of our agenda today are updates from the DOJ, and then we'll have a conversation about the public chat function and a vote and a possible action item on that. So without further ado, I'd like to turn to Michael Newman. Thank you. Oh, Vice Chair, Member Tamaki, you're recognized.
I presume with this, we've approved the outlines so that the DOJ can proceed, unless that has to be done by motion. But I just want to make sure that the DOJ, because we're under a pretty aggressive time frame, that's going to proceed. And just to comment, I think every member's comments are really great and really helpful. And some of the things that were raised, I guess it's a question of whether they should be raised in a different section. For example, the part about discipline in education, a lot of that ends up in the family, but maybe it should be moved to education. And with respect to, we just talked about domestic violence, whether that could be reframed as a mental health issue, maybe belongs there. So perhaps the advisory committee that's working on the dictionary could also provide some guidance to the DOJ. But I have to say, in general, I think the DOJ team did a really good job. And I just want to point out that this report is different, for instance, than the 1968 Kerner Commission. I mean, I think the Kerner Commission arrived at the right conclusions. But if you look at the history portion that talks about slavery and Reconstruction, Jim Crow, redlining, and so on, it's literally about 50 pages. And this is a really massive and comprehensive connecting the dots between past racism and current consequences. And I think as far as the American public is concerned, it's going to be an eye-opener and something that will be looked upon by other states and other leaders. So I think, I just want to say that I think the outlines are really a great start for the report. And it will have to be very heavily footnoted with authorities noted, but I really think that this is a good deliverable for the task force. But with those changes that the members suggested.
Thank you.
Can I just echo what Member Tamaki said? I think that a tremendous amount of work has gone into these. They're very comprehensive and will take us a long way in being able to do some of the discussion that we need, that our speakers today pointed out, particularly around being able to name the harms and use that in consideration of some of the deliberations that are coming.
So at this time, would any task force member like to entertain a motion in regards to the California DOJ being able to proceed with the section?
So moved.
Is there a second?
I second.
So it has been properly moved and seconded that the California Reparations Task Force authorizes the California DOJ to proceed with the second draft of the outlines based on the conversation and consensus that the task force has just come to today. Are there any comments, discussion on this matter, rather?
Madam Chair, could you please identify who made the motion and the second?
Member Tamaki made the motion and Member Javon Scott Lewis seconded.
Thank you.
And I think just to correct the motion, Camila, sorry, no offense intended.
Thank you.
My understanding is that the report is that the authorization is
Not a
direct
second
to direct DOJ to direct them to proceed with the drafts of the report. We're not going to see another set of outlines, but rather it will be proceeding ahead with the draft report.
Right.
Thank you so much for that clarification. So it has been properly moved and seconded that the task force authorizes the California DOJ to proceed with the drafting of the report based on the conversation that we had today. Are there any other discussion on this matter? Again, the vote is to approve the outlines and to move forward with the report. Hearing no further discussion, we will turn to Parliamentarian Johnson for a roll call vote. You're on mute, Parliamentarian Johnson.
Chair Moore, thank you.
Aye.
Vice Chair Brown. Member Bradford. Member Grills.
Aye.
Member Grills votes aye. Member Holder.
Aye.
Member Holder votes aye. Member Jones Sawyer.
Aye.
Member Jones Sawyer votes aye. Member Scott Lewis.
Aye.
Member Scott Lewis votes aye. Member Tamaki.
Aye.
Member Tamaki votes aye. Member Montgomery Stepp. Madam Chair, there were 6 votes cast, 6 ayes and 0 nays.
Thank you. So the motion carries. The ayes have it. So the motion carries. So we will move to the next item on our agenda. Thank you again to California DOJ staff for these outlines. As Member Grills and Member Tamaki said, these were absolutely outstanding and gave us a lot to work with. So we're definitely looking forward to the final outcome of the report. It should be groundbreaking. So, Mr. Newman, the floor is yours.
Thank you very much, Chair Moore, for recognizing DOJ staff as you've just done. And I'm glad they were able to be on the meeting during this discussion so they could hear the positive comments. We really appreciate the feedback and comments and appreciation. I can say everyone's worked very hard to get where we are, and appreciate those comments. With today's DOJ update, I want to follow up on several items discussed in my last DOJ updates and share some additional updates and information. During tomorrow's business session, we will be reporting out on or addressing a number of issues that have been raised by members or represent important business for the task force to address, including the required conflict of interest code, the task force's contracts and contracting process of the state, the addition of a January meeting on health and other issues, meeting on Saturdays, and various other matters. I will therefore hold any updates on those issues for the relevant discussions of each as included on the agenda, but we'll be happy to take any preliminary questions you may have on anything now if there are questions that may require overnight consideration by me or DOJ staff or research in advance of the discussions tomorrow. For now, I will say that taking all of your comments and input from the last section of the meeting we just concluded, we'll now turn to fleshing out the outlines you have just approved and returning to you in, I believe, the February meeting with draft sections for your further consultation and discussion. And of course, that'll be an ongoing process, including with the advisory committee you've all just created. We look forward to assisting you all in crafting a report that will convey all of the critical and impactful information being developed in the task force's meeting and research and developing an excellent compendium of information that should be groundbreaking and meet with the legislature's mandate. The most significant update I have at this time for this meeting is with regard to the meetings of this task force from February 1st, 2022 on. Under the Bagley-Keynes normal procedures, members of bodies are required to physically meet, members of state bodies are required to physically meet at a publicly noticed meeting site where the public will also be able to join. Members may only attend meetings remotely under limited circumstances, and all sites from which members attend must be noticed and open to the public and must be compliant with the Americans with Disabilities Act. These permanent requirements were modified by an executive order issued by Governor Newsom to allow for remote access, such as we are all using now, to curb the spread of the coronavirus. These modifications were extended through January 31st, 2022 through AB 361. But the exemption in AB 361 will end on February 1st, 2022, and return us to the requirements of the permanent law. Therefore, as of the task force's February meeting, which we'll discuss more tomorrow, we'll be required to schedule in-person meetings for the task force, which will mean the following key points. First, all task force members will be required to participate in the meetings in person, or if a member will be participating by teleconference from another location, we will need to know the location from which you are participating, and that location will be required to be included in our formal notice of meeting, open to the public and accessible for persons with disabilities. Second, the DOJ will need to brief each member on the process for scheduling travel to the location of the task force meeting and receiving reimbursement for attendance, which DOJ will coordinate through the state's travel reimbursement program. And we'll follow up with each of you one-on-one to provide all of the information, training, documents, et cetera, that you may need to be able to carry all that out. The task force, when setting future meetings, will need to also select a location in which each meeting will take place, in addition to the dates. Members can volunteer specific facilities or locations, or you could vote on a city in which you would like the meeting to take place, and DOJ staff can coordinate a location. And again, we'll discuss this more as we schedule each meeting moving forward, so that we can be responsive to the task force's directions and requests. And finally, the task force may need to seek an appropriation from the legislature, or DOJ may need to seek a supplemental budget change for per diem compensation and reimbursement of expenses for not more than 10 meetings as set forth in the statute. The 10 meetings that are stated in the statute are, set the cap on expenditures for these purposes, and those will kick in once we start meeting in person. I recognize that for this task force, the shift to in-person meetings represents a significant transition because you've never actually conducted an in-person meeting. We hope that having an opportunity to meet and hold a meeting in person in February will create opportunities for individual engagement of the members of the task force. As part of your discussion tomorrow in setting the agendas and dates for future meetings, you may want to also consider the location or locations, as I mentioned, in which you would like to have these in-person meetings take place. We look forward to working with each of you individually to support this transition, and we will provide another report in our January meeting when things become a little bit more concrete after you've had a chance to discuss, and we've had a chance to discuss with people, without all the members of the task force one-on-one. With that, thank you very much, Chair Moore, Vice Chair Dr. Brown, and members of the task force for providing an opportunity for the DOJ to provide this important update. I welcome any follow-up questions from any members of the task force about the in-person meeting, other items, or as I mentioned, things that may come up tomorrow, or anything that I have not addressed that any members wish to seek clarity.
I think I can only see you on the screen right now, Mr. Newman, but I did have a follow-up question. It's something that we can discuss so at a later date, but when we do transition to person meetings, will there still be capability to stream online, like for people who won't be able to attend in person?
This is a good question. Dr. Brown, do you have a, what? No. Sorry, Chair Moore. It's a really good question. I think that is something we are still needing to look into. All I can say is typically, if you look at the way the legislature conducts their work right now, what they do, and Member Jones Sawyer may be able to speak to this, but the legislature has sort of a camera that films, and I think it goes onto the website. But all the business of the meeting is conducted via phone. People calling in and offering testimony over the phone, and members sort of sitting in the meeting and listening to the information coming in over the phone. So I think we're still exploring what this means technologically, not just for this task force, but obviously for the dozens or hundreds of other state agencies that are making this same transition.
Okay, thank you. Are there any other updates from you, Mr. Newman?
No, that was the big update. And then tomorrow, as you see from the agenda, as we've discussed, there are a number of different items that the DOJ will be reporting out on and eliciting questions on throughout the day. So that'll be probably saving everyone's time. That'll be probably an opportunity for us to get more into detail on the different aspects of those issues.
Okay, thank you. Are there any, Member Holder?
Yeah, I'm just wondering, and you may not know this, Attorney Newman, what kind of COVID protocols there are going to be for in-person meetings, whether there's like a rapid test requirement, stuff like that, whether that's, what stuff that the DOJ is, implementing or thinking about right now, and how much lead time will we have before, so that we know what kind of COVID protocols are going to be in place.
Yeah, this is a significant concern, and I understand that. We're still looking for guidance. I think we're hoping that there will be guidance coming in January, potentially from other state departments that are responsible for health response. And we'll be talking with each of the members of the task force over the course of the next month, and hopefully have some clearer idea by the January meeting that we can report out on that meeting. But this is certainly something we would need to develop in advance of any in-person meeting. And so we expect that there should be some more guidance as we close in on the February 1st date set by the statute.
Okay, thank you. Are there any other questions for Mr. Newman? If not, we can move on to the last part of our agenda. Okay, thank you, Attorney Newman, and we'll see you tomorrow.
No problem.
Thank you. Thank you. So then the last part of our agenda for today is a review and discussion and possible action item about the public chat function. So yes, and if Attorney Newman, if you want to come back on for this, you can. But essentially, the public chat was on. Oh, Attorney Newman, can you just kind of give an overview on?
Oh, sure. No, I can't. Sorry, I just popped off. I didn't know if you wanted me. In the first meeting that we had, the first meeting which lasted one day, we had inadvertently had the public chat function on in the Blue Jeans events. That's not our normal process, and as we mentioned in the last meeting, the public chat is not particularly, especially with regard to the way the Bagley-Keene Act usually operates. The public chat function is not something that's normally available. It's sort of outside of the realm of public comment, where you all, members of the task force, have allotted 2 hours of each meeting, 1 hour each morning, to public comment. And so we did not have the public chat function on. But as I briefed you all in the last meeting, if the task force would like to activate the public chat function, it's well within the task force's ability to direct us to enable that in the Blue Jeans events platform. And obviously, in the last meeting, there was a lot of discussion as to people's feelings regarding what was in the chat. And the only thing I'll mention, the one last thing I'll mention, is we do not have an ability to moderate the chat. So the chat is either on or it's off. It would not be moderated, and it would become part of the official record of the task force that would be published with the meeting materials for each meeting in advance of the next meeting. So that would be included in the chat, in the public chat, would be part of the public record.
And I can't remember, is the public chat visible during the meeting to task force members?
Yes, it would be. And anybody logged into the Blue Jeans platform.
Thank you for that review, Attorney Newman. So now that we reviewed the situation, we can have a discussion on whether or not we think that the public chat function should be reinstated or not. And then we can have a potential action item around this. So does any task force member in particular want to speak or have a comment on the proposition of whether the public chat function should stay disabled or whether we should reinstate it? And if it is reinstated, are there any comments about best practices or things like that?
So this notion of best practices is, I don't know what best practice there is when you can't moderate the chat. And so that really presents a challenge to me, because if I am to be frank, I did look at those public comments in the chat in that early meeting, and some of them were very good, very substantive, good to see, good to hear about, and some of them were quite frankly just mean, nasty, cruel, and not helpful, and harmful, to people who folks were talking about potentially, right? So it's without having the ability to do the best practice that is out there where you can moderate the chat, I feel like we have a real challenge here, because there is a benefit to hearing, but there's a real problem with not being able to manage it in ways that don't allow people to be disrespected, and that couldn't, frankly, just we could be invaded by people whose only intent they're not interested in reparations per se. They're interested in denigrating the process. And so how do we protect against that? I don't know, without being able to manage the chat function. So I'm not saying yes or no. I'm just presenting conundrums as I see them.
So so in my committee meetings, public safety, as you can imagine, I've been called everything but the child of God, in person and in a chat and in emails and text messages. But during my meeting, especially now that we're in this COVID procedure, I don't see those. They do come in, but I don't see them. So I don't know why it's mandatory that while we're in our meeting, we, the committee members, have to see it in real time. When in other committees, you don't. In the Assembly and the Senate, you can look at it afterwards. When you have real in-person, there's rules of decorum. So obviously, if someone is using language that is not PG, and again, if someone is making personal attacks on anyone, we have sergeants that are in the room that will remove that individual. And there have been times I've even had to gavel down, which means stop the meeting because people are so violent and expressive that I've had to go into recess, have those individuals, that person removed, and then we've come back when civility has reigned in the room. So I'm probably one of the few that's probably used to having people say some disparaging things about them in public in real time. And so I know it's very hurtful, and it's not appropriate, and it is distracting. So is the issue that as we're debating or discussing, we'll look over and glance and read something and that'll just throw us off, or we'll immediately start trying to answer something that's there when we really should ignore it. From my perspective, what has helped me, people who are very, who don't comport themselves in a logical way, they lose their point of view. So if they're cursing and screaming and not acting in the correct way, they lose their point. And it becomes easier for my committee, public safety, to make decisions about which way to go, because those individuals were so, I'll be honest with you, racist and radical, that we knew we weren't going to go in that position. Look, I always mention my uncle in Little Rock 9 and what he went through. But I know those people were at least honest and told them to their face what they really thought, and used language which was offensive, but he knew how everyone felt. Nowadays, you don't hear it. I think especially recently, you don't hear that. So it is a little jarring that now, and I'm not going to get into politics, but now because of certain folk, people feel empowered to say things that they wouldn't have said 10 years ago, especially to African Americans. And so, yes, it could be a little jarring, but I can't speak for everyone on the committee. I rather out them, see them, know where they are, than push them down and have them hidden somewhere. So, but I'm just one, as far as that concerned.
I have another technical question about anonymity and what you just said. Member Jones Sawyer made me think about that. Civility and anonymity, and how civility often goes out of the window in this day of social media when there's anonymity. And so maybe that is one way to put a check on people. They have to be open about who they are before they say something. So I don't know whether you can make your comments anonymously or whether your name goes.
We can look into this question. Sorry, may I, Chair Moore?
Yeah, sorry.
I think that the way the Blue Jeans platform works is that their comment would be linked to the name that they log in as an attendee for, and they are able to use whatever they log in as their name. So I'm looking at the attendee list right now, and a lot of these are not probably given names, I have to presume. So that would be the name that the comment would be tied to, which would be some level of anonymity if they choose to have those different kinds of names.
Yes, I just wanted to put into context that, this conversation is kind of moot after February, right? Because we meet in February. So, there won't be any public chat function once we start to meet in person in February. So I guess this would apply to tomorrow's hearing and the January hearing, whatever we decide. Just putting that out there. Member Tamaki, you're recognized.
So the thing about the chat is I can't read chat and then concentrate on what the speaker is saying. So I want to give every speaker and every person that speaks in the public comment section and every invited expert and lay witness who testifies my undivided attention. And for that, I mean, it's hugely distracting. What Representative Joan Sawyer says is absolutely right. I mean, when you're reading chat or you're answering something, you're not listening to the person speaking. And, in the ideal world, everybody who logs in, whether from the public or participating in the task force, should be listening to the speaker. And we do have allotted time for public comment. I read every single email that is sent to the task force. I read every single converted phone message. So I am paying attention, but I can't read chat, especially when I should be listening to the speaker. But that I guess that's one comment. And then as we move into the public session, the face-to-face session, on the one hand, the chat function allows people to express obviously their thoughts. On the other hand, if you were in a public meeting, you might be able to talk to the person sitting next to you, but you couldn't address the whole audience. And electronically, chat does that, and it becomes a huge distraction, I think. But those are just my comments. Obviously, I'll go along with whatever the task force decides, but I think if you can't moderate it, we do have this phenomenon in social media of people being keyboard gangsters because of the anonymity and being trolled by people who have no intention of supporting reparations or want to hear what we have to say. So it opens up some problems. That's all.
Can I make a suggestion as maybe a compromise that we don't open up the chat, but we explain as we open up each meeting why we don't open up the chat, so that people who do want to have this chat, they will know, oh, you're not pushing me out, or you're not trying to push me down and make sure you don't hear from me. There is a very good reason why we're not doing it, and maybe DOJ can help us, right? Because we do short comments about COVID. Why we have rooms where you can only so many people can meet in a room. There's an adjunct room away from the Capitol. You can call in, and we have a procedure for how we take in information. Maybe we should have something that the chair can briefly read about why we're not openly doing this, and incorporating that this body wants to make sure they have full attention to the speakers, to each other, and making sure that we're totally focused on ensuring that we get the right information that we need so we can make an informed decision, and that there's some distractions which comes with an open chat that may not be either germane to the subject or even helpful in our deliberations. And I know that's probably too long of a disclaimer, but you get what I'm saying. Some kind of disclaimer so that people know why we did it. That we're not trying to hide. In fact, we're trying to be as professional and inclusive as possible, and respectful for each other and the people who come to speak before us. So you want to put that in a motion, or what? Everybody's kind of looking. Is that what you were looking for, or is it just we just do it, or we got to do it formally? Madam Chair.
Well, again, this would literally
Chair.
just apply to tomorrow's hearing and the hearing in January.
Correct.
I think before we make any motion, I just want to make my thoughts clear about where I stand on this issue. And so, as chair of the Reparations Task Force, I can say I do not condone any, harmful language, whether that's racism, homophobia, transphobia, xenophobia, classism, none of that type of language it should be tolerated. So I just want to make that statement clear. In conversations with Secretary Shirley Weber, early on in this process, she made it, clear to me that, a public chat function would be beneficial, despite the negative commentary that might come with it, because I think member Reggie Jones Sawyer said earlier, you kind of want to see who's against you, who's for you. You want to see it all, because if you just disable the function, you're kind of they don't go away. The negative commentary doesn't go away, you just don't see it. And that isn't necessarily beneficial to this process, I think. But at the same time, I'm balancing that rationale, that Weber proposed with the realities that, words hurt and words matter. And that, this needs to be, a process where people are respected. And so, yeah, that's where I'm at. I'm a bit conflicted. Now, I think the first meeting was kind of a one-off. There were a lot of different people there. I think a lot of people in the chat were bad faith actors that I don't think I've seen since that first meeting in the chat. So, I say that to say I'm not sure if, those types of comments would reemerge, given that we've, kind of gone along with our process, and, highly engaged community members have stayed committed to this process, and I think the bad faith actors have gone away. But that's just, that's my take on it. But I'm open to hearing any other comments from the task force, and we can just get to a motion.
Point of clarification, are you saying that we have to show everything that, because I think in other formats, you can exclude, you don't have to show it here on the screen. You can have your comments come in. I'm not talking about stopping comments from coming in. I'm talking about having it show up while we're deliberating and talking at the same time. So you're saying this blue jeans or whatever this thing is can't, then we should stay with Zoom. I mean, you pick something that doesn't comport to what we want. So you're really talking about a technological problem, not necessarily because I'm with the chair. I'm not trying to stop anybody from commenting. I want people to comment. I just don't want them to distract us from our meetings. And you're saying we can't do that.
Well, then I have a follow-up question because for Blue Jeans,
I don't know if you answered that. Is that what it means? That we have the technology won't allow us to do that?
Yes, sorry, I didn't want to
yeah, I think
interrupt.
that's
Oh,
go ahead,
no,
Attorney.
am I
Lee.
me?
Wow. Okie dokie.
Sorry, did you want me to respond to that? Am I?
Yeah.
Yes.
Am I on mute? Okay, you can hear me. Good. Sorry, I didn't know if I was. So yes, Member Jones Sawyer, that's correct. Under the Blue Jeans technology does not allow, as far as we know, we can look into it before the next meeting. We can consult with them. But yes, that is correct. The platform itself, once the chat is turned on, it is on and visible to everybody. Now, you can, I mean, there's a menu on the right-hand side that has chat, which I think can be open and closed. And you know, you can change the configuration on your screen while you're in the meeting. So that is controllable. I think the issue is if chat is coming through, you will see that sort of the numbers start popping up on the side of the screen, so you'll know chat comments are being made. Some members may be viewing the chat. Some members may not necessarily be viewing them all, but they'll be coming throughout the meeting. But you do have the ability to change your view using the menus on the bottom left-hand side and on the right side of the web view for Blue Jeans events. But that being said,
no. Let me try this again, because I haven't seen any chats. So if no member on this committee opens up that chat, they don't see anything. But if they open it up, they'll see everything. Is that where we're at?
Yes, that's correct. That's exactly right. It's the same as
John
Zoom.
Kamaki wants to concentrate exclusively on this meeting. He just shouldn't open up that chat.
Yeah.
Is it that simple?
Yes, it should be that simple. The chats will still be coming through. The comments will still be coming through.
I see it now. What is it? 4?
There's no way to block out members from seeing the chat in meeting. It wouldn't be something
if they want to. If they
Correct.
want to. I thought it was, because I haven't seen the chat at all, and I realize now because I never opened up because it's distracting. So is that the solution? We let the chats come through and you just leave it alone and just concentrate on the meeting? Or am I out of line again?
Well, I had a quick follow-up question. So the Blue Jeans has a distinction between backstage chat and moderator chat. So I guess my question is, if the chat function is open back up, the comments from the public, will they be seen in both the backstage chat and the moderator chat, or just the moderator chat?
No, so what you're referring to are the chats that we're utilizing to sort of give stage directions, like if time is running out, or if people should be moving on to the next thing, or if a slide should be up or not. Those are really, that's what the backstage chat is. And then the moderator chat is for people logged in as moderators. So this would be a third form of chat that would be open to all of the people, all the public, as well as all the members of the task force who are logged in as moderators. So it's 3 different kinds of chat that would each be separate. So the public can't see the backstage chat, which is the internal stage direction.
And the public can't see the moderator chat either unless they're promoted to being.
Yeah, that's correct. I don't even know, I mean, we don't have anything in the moderator chat, but I don't know if while they're promoted to give public comment, they would be able to see it or not. I'm not sure.
Okay. I guess another point of why, oh, go ahead, Member Holder, you're recognized.
Just in the interest of time, maybe we can just do a poll. A quick poll, to see where people are, and then move to making a motion. And it seems like if the default is that there is no chat, then if the motion is that there is no chat, then that seems unnecessary. There should only be a motion if we want to enable the chat. Just as a point of order, right?
Yeah, I guess one last comment from me. I think one of the other reasons why I think people wanted the chat to be enabled, the people who are engaging in this process in good faith, is that, they might want to ask questions to the panelists, so that could help, particularly if there's like a lull. We can get a question from the public directly, and we can pose that question to our panelists. So that's just a pro for enabling it, but also recognizing the many cons as well.
So we're going to ask each one how we feel, and then decide whether or not to take a vote. It's after 5. Oh my God, it's 5:30, and we kind of promised the public we'd be finished by 5.
So we can take a poll, and then we can take a poll. Member Tamaki?
I'm very conflicted, but I don't want this to be a sticking point for the task force. I mean, Reggie John Sawyer, you're right. We don't have to activate the chat and just ignore it. And maybe that's the solution. I'm not in a big fan of the chat, but I'm not vehemently opposed to, keeping it on. So that's not really a great answer, but it's just to say that if anybody else has strong feelings about it, I'd like to hear it. But I'm really in the middle of this. For me, it doesn't help me. Because I think it's a huge distraction. And if it's a distraction to me, I would think it's a distraction to everybody, including the audience. But maybe I'm wrong on that. So.
There's 6 of us left, so, and I'm conscious of time, and I also don't want to lose a quorum. So.
Yeah.
I just want to make a motion, either way.
Chair Moore, just to follow up with Member Holder's suggestion, could you just ask those who would be okay with opening the chat, raise your hand, and we can get a sense, okay, of whether or not we need to make a motion.
Okay, so those who are okay, well, Dr. Brown is also busy, so who would be okay with opening the chat? Dr. Brown, are you here with us? So we're taking a quick poll on whether we would be okay with opening the chat. And I think all of us raised our hands a bit with some caution. So Vice Chair Brown, do you have any strong opinions as to, would you be okay with opening the chat? I think that's the question on the floor. Would you be okay with reopening the chat for tomorrow and the January hearing? And
I've always been for openness and transparency. Always.
Okay. So now that we've taken a poll, should we take a motion at this time? If so, yes,
I'd like
Member
to move,
Grills.
I'd like to move that we reopen the chat for the remainder of the December meeting and the January meeting.
I second the motion.
Okay, it has been properly moved and seconded that the public chat function is restored for the remainder of December's hearing and January's hearing. Is there any discussion? I guess I would just briefly reiterate that, if this motion passes, that we communicate, collectively as a task force that, again, we don't condone any harmful language, and that, we would communicate to the members of the public that in, reopening this chat, we are, restoring trust back into the public and hope that a reciprocal relationship, is respected, that they see that this wasn't an easy decision if the motion passes, and that the members of the public act accordingly.
And Madam Chair,
Yes.
if I can bring up the motion, and
Madam
if
Chair,
we just cut them off.
Call the roll.
They do, cut them off if they do go the wrong
Call
way.
for the question. Otherwise, you're gonna lose your quorum.
Okay. Are you ready?
Okay. Yes, Parliamentarian Johnson.
Okay. Chair Moore?
Aye.
Chair Moore votes aye. Vice Chair Brown?
Aye.
Vice Chair Brown votes aye. Member Grills?
Aye.
Member Grills votes aye. Member Bradford? Member Holder?
Aye.
Member Holder votes aye. Member Jones Sawyer?
Aye.
Member Jones Sawyer votes aye. Member Scott Lewis? Oh, okay. Member Tamaki?
Aye.
Member Tamaki votes aye. Member Montgomery Stepp? Okay. Madam Chair, there were 6 votes cast, 6 ayes, no nays, and no abstentions.
Thank you, Parliamentarian Johnson. So there were 6 ayes, so the ayes have it and the motion carries. So the public chat function will be restored for the remainder of December's hearing and the January hearing. Okay, thank you. So that was the last item of our today's agenda. So again, thank you to members of the public and the task force. We will recess until tomorrow at 9 a.m. Thank you again, and have a great evening, and see you tomorrow.
Good night. Safe travel.
Good night.